December.
अरे
जर नहीं आते हो दे
चलो आम्हाला
गेले का मामा?
दोन मिनिटं भाऊ मोबाईल पडला तुमचा.
हाल बघा
Matter of 2018.
No, sir. Not possible. Not possible, sir. Not possible, huh? Memo for withdrawal.
Your Honor, petitioners, the 1-year-old child and wife, Your Honor. Petitioners are the 1-year-old child and the wife.
What do you want, sir? Huh? What? Is it a fresh matter? What is this? It will come up tomorrow. Any difficulty?
The agency is that, Your Honor, the entire insurance amount is going to be transferred in the name of the nominee, which is the mother-in-law, Your Honor. If that doesn't happen, the wife and the 1-year-old child will have any.
Come tomorrow. Yes. The other side here. On reach other yes.
The petitioner, my lord. This case, my lord, I'm thinking for the mandamus, my lord. The petitioner, my lord, appointed as a bill collector on 2000, my lord. And it has been approved by the Jilla Panchayat on 2014, my lord. Now, my lord, my representation is given, my lord, in respect of my lord, next promotion is concerned, my lord. I have given representative next year J, my lord. Now, earlier past service may be considered for that, my lord. That is the reason, my lord.
Learned AGA. Takes notice for respond number 1. Issue notice to response number 2 to 4. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures from the learned AGA.
Meanwhile, my lord, standing counsel of the Jilla Panchayat, my lord, may I serve?
Yaradu?
Yarindra avರಿಗೆ ಕೊಡ್ಬಿಡಿ.
My lord, I appear for the petitioner, my lord. In this case, my lord, the petitioner has been working as junior training officer for the last 13 years, my lord. Annexure A is the first order, my lord, at page 35 on 2012-2010, wherein, my lord, the petitioner's appointment, my lord, has been approved by the government, as well as, my lord, it is in the aided post.
Interim prayer to release the salary.
ಅಲ್ಲ ಅದು ಅಯ್ಯೇ ಒಂದು ಹಾಕಿದ್ದೀನಿ, ಅಯ್ಯೇ ಒಂದು ಬಂದಿದೆ, ಸ್ಟೇ ಆಫ್ ದಿ ಆರ್ಡರ್ ಅಟ್ annexure L, my lord. Annexure L, page 92, quite separate ಅಯ್ಯೇ, my lord. Annexure L, my lord, page 92.
ಏನಿದು? What is annexure L?
Annexure L, my lord, is the order by which, my lord, the petitioner, my lord, that salary is ordered to be recovered, and there is no question of, my lord, permitting him to adjust in the aided post. Aided post, he has already been working. Page 94.
ಏನ್ ಮಾಡಿದಾರೆ ಇದರಲ್ಲಿ?
ಇವಾಗ by this, my lord, page 94 ನಲ್ಲಿ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಡಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಆಮೇಲೆ ವಾಟ್ ಎವರ್ ದಿ ಅಮೌಂಟ್ ರಿಕವರ್ಡ್, ಇದು ಪೇ ಟೈಮ್ ಶುಡ್ ಬಿ ರಿಕವರ್ಡ್ ಅಂತ. From 2009 onwards till 2012, my lord, he has been paid his salary as a aided post. That is ordered to be recovered, my lord. I had challenged both the orders in the previous petition, my lord, by which there was a direction to consider it as a notice.
ಸಂಸ್ಥೆಯವರಿಗೆ
ಸಂಸ್ಥೆಯವರು directions ಕೊಡ್ತಾರೆ. ಸಂಸ್ಥೆಯವರು intern, my lord, they have made a communication to me.
But there was earlier one more writ petition.
I have filed, my lord. I have filed writ petition.
2 more writ petitions.
ಅಲ್ಲ, ಹೌದು, 2 writ petition ರೆಡಿ ಮಾಡಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ. There was a direction, my lord, to consider his, the orders were read down as a notice, and I have given a detailed reply. He has been working, my lord, from last 13 years in the aided post. He has also paid salary till 2012. 2012 onwards, my lord, they have not been paying salary. For this, my lord, there are 2 orders of this honorable court.
Learned AGA takes notice for response number 1 to 4. Issue notice to response number 5 and 6. Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. Since there is a direction issued by the second respondent, commissioner, to the fifth respondent institution to recover the excess salary said to have been paid to the petitioner, there shall be an ad interim order of stay of the operation and execution of annexure L dated 29/10/2021 till the next date of hearing.
With all further proceedings, my lord.
Yes.
I appear for the petitioner in this case. Petitioner is the wife of one Nagesh who retired as junior engineer, KPTCL. Pensionary benefits have been withheld for release of pensionary benefits.
There is no interim prayer.
No interim.
At council, Shri A. Chandrachuda is directed to take notice for respond number 1. And to JESCOM ग्यारह पे रखते रहे Bidar.
JESCOM Israeli, after his death merits, she is residing here with her daughter. I will take notice.
But your pensionary, his pensionary benefits was required to be settled where?
The KPTCL direction ಮೇಲೆ ಮಾಡಿರೋದು
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು
ಅಲ್ಲೇ JESCOM ಇದರಲ್ಲೇ ಬೀದರಲ್ಲೇ ಮಾಡೋದು
ಮತ್ತೆ
problem is she is residing here now after the death of her husband with her daughter she is residing.
Issue notice to response number 2 to 4. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on learned counsel for respond number 1.
His service was regularized from 26th to 1987. After his retirement, their services were not, procedure was not followed, stating that the DPR guidelines were not followed. Everything was followed. I produced the material before this honorable court, the honorable minister for the approval of the honorable secretary and the approval of the honorable minister for medical education was sought, and they postponed my date of regularization. Not only mine, not other persons also. I have already challenged the order by some other person in WP number so and so. And this petition, what has happened? Originally there was a ATCP, anti-tobacco community program, that was converted to ATC in the institute itself. Not that.
What is annexure P?
Annexure P is the letter from the government to the institute to refix the pay, to postpone the date of regularization. Pursuant to this, they issued a notice, rescind the original order at 26th and 1987. That was direction. The order was not rescinded by the institute. They refixed the pay, and consequently, the pension was reduced.
What interim order can be given?
Annexure L, not that.
Stay ಮಾಡೋದು ಏನಾಗುತ್ತೆ?
Notice order.
The learned AGA takes notice for respondent number 1. Kidwai ಯಾರ ಪೇರ್ ಹಾಕ್ತಾರೆ? Issue notice to respondent number 2. Huh?
Other matters I can maybe connect along.
Learned counsel for the petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. List this matter along with WP number 22570 of 2021. ಅಲ್ಲ ಒಂದು ಕಾಕಣ because the other one 3902 if it is already connected to that one then
matter pertaining to compassionate appointment of a divorcee daughter. A petitioner's father expired on 29/8/2019, my lords.
who appears for this veterinary university? It is SWAS, veterinary university, agricultural university alla, veterinary animal and fisheries sciences university. Huh? Council Shri HS ಯಾರಿದಾರಪ್ಪ? ಅದೇ ಈಗ ಅವ್ರ ಜಾಗದಲ್ಲಿ HS ಸುಹಾಸ್ ಅವರೇನಾ? Learned counsel Shri HS Suhas is direct take notice for the respondent university. Learned counsel for the petitioner is direct to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent.
Teachers.
Honorary teachers.
Teachers working in a lot of residential schools. Non-teaching staff also. Similar matters to lodge as ordered. Annexure F is the interim order passed earlier. Annexure J3 page 173 is the interim order. 73.
Not to relieve, huh?
Not.
Learned AGA takes notice for the same
Correspondence 1 and 2 and
1 to 5 to 26.
5 to 19. 5 to 19.
5 to 19.
Yes.
Learned AGA takes notice for response number 1, 2, and 5 to 19. Learned counsel Shri Nagaya
3 and
is directed to take notice for response number 3 and Mikidella same as page number 173. WP number 5359 of 2020.
Is the retired principal of the aided college, my lord. Direction to pay the stagnant increment, my lord. Covered by decision of this.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is direct to serve copies of the writ petition along with annexures on the learned AGA. Yes.
Covered by decision. Date may be fixed, my lord, after vacation. Covered by decision of this.
Paradil.
Petitioner is working as a chief officer, Lord, of a town municipal council, Bommasandra. Lord, he is in the cadre of office manager. The next promotional post to the petitioner is that of chief officer, Lord. Accordingly, Lord, the petitioner was found to be posted as a chief officer by order dated 29/9/2020 by the government, annexure B. Lord, the government transfer guidelines specifically states that, Lord, a person should not be left without any posting. That para 5 and para 6(2) specifically says that, Lord, that a person, if he is not available, then only a deputation should be resorted to. Such being the case, Lord, when the petitioner has not even served for 1.5 years, Lord, the government has passed an order, Lord, specifically posting the second respondent who is an officer of the Rural Development and Panchayat Raj Department, who is not a department municipal employee, in the place of the petitioner, and petitioner has been transferred without giving any posting. Though, my lord, this honorable court has specifically held in Seema's case that, my lord, and also the respondent, the government itself had issued circular very number of times that, my lord, no person should be left without any posting, and such transfer should be deprecated. Even then, my lord, the respondent government has passed an order posting the second respondent in the place of the petitioner, and petitioner has been disturbed without giving any post.
Learned AG take notice for respondent number 1. Issue notice to respondent number 2. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Next para. Learned AGA is directed to secure instructions as to why no posting is given to the petitioner. So, release this matter tomorrow. Get instructions.
This is regarding election to the post of director of the respondent 5 Milk Society. No notice was issued. This is for voting and contesting. No notice was issued to the petitioners for to the general body meeting. And this is basically a milk society. Milk society minimum transaction ಮಾಡಬೇಕು ಅಂತಂದ್ರೆ milk supply ಮಾಡಬೇಕು. ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ
Sir, if you are making submissions on factual aspects, this is not the forum.
Please
Go before the authority.
please
What do you want?
contesting and voting.
Huh?
Contesting and voting.
Paradilla. Paradilla, sir.
No notice was issued.
We can't issue any directions contrary to the statutory provision. If they have pointed out to a provision and they have said there is violation of that one and therefore you are disqualified from voting, how can we pass the directions telling them no, permit you to vote and contest? That provision was questioned.
Please,
The validity has been upheld. Then,
no notice was issued.
so therefore, if that is the contention of you on the factual aspects, you should have approached the authority. We can't go into the factual aspects here under 226.
13B ಕೆಳಗಡೆ IDC ಅದು ನಾನು ಗ್ರೌಂಡ್ ಕೂಡ ತಗೊಂಡಿದ್ದೀನಿ. ಮಿನಿಮಮ್ ಅಂತಂದ್ರೆ ಮಿನಿಮಮ್ 6 months ಬಿಫೋರ್
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದಪ್ಪ. All those factual aspects cannot be gone into here. You should have approached the authority.
Lordship yesterday, colleague matter also. Permission to contest and vote.
No. The issue there was different. They had not given any information, or probably that. Ade.
No notice was issued to the petitioners.
There is no question of issuing notice to you, sir. If they have prepared a separate list giving reasons why you are not to be considered as an eligible voter.
ಯಾವುದನ್ನು ಮಾಡಲೇ ಇಲ್ಲ. ಯಾವುದನ್ನು ಮಾಡಿಲ್ಲ ಇದು. ಅಲ್ಲ ಅದು ಮಾಡ್ತಾರಷ್ಟೇನೆ.
But they have not assigned reasons.
Reason ಕೊಟ್ಟಿಲ್ಲ ಇದು. Kindly see.
Annexure C.
Annexure C, page number 24. ಬರೀ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಬಿಟ್ಬಿಟ್ರೆ ಅವರು ಎಲ್ಲೂ ಕೂಡ they
have not assigned reasons.
Total 172 shareholders ಇದ್ದಾರೆ. ಅದರೊಳಗಡೆ 99 members are disqualified. 99 members are ineligible to.
ನೀವೇ ಹೇಳಿದಿರಲ್ಲ, ineligible because of not attending 3 general body meetings and declared as ineligible.
ಅಲ್ಲಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು, but there is no assign.
ನೀವೇ ಹೇಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದಿರಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ನಾನು ಅದನ್ನ I bring into the notice of court, madam. I bring into the notice of court.
how can you bring it to the notice of the court, sir?
ಏನಂದ್ರೆ 173 ಮೆಂಬರ್ಸ್ ಅಲ್ಲಿ
If you said there is no reason assigned, ನೀವಾಗ ನೀವು ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
173 ಮೆಂಬರ್ಸ್ ಅಲ್ಲಿ 99 ಮೆಂಬರ್ಸ್ ಆರ್ ಇನ್ಎಲಿಜಿಬಲ್ ಟು ಕಂಟೆಸ್ಟ್ ಅಂಡ್ ವೋಟ್. ಅದನ್ನ
When is the election scheduled to be held?
ನಾಳೆಗೆ ನಾಮಿನೇಷನ್ ಫೈಲ್ ಮಾಡಬೇಕು. 30ನೇ ತಾರೀಕು ಎಲೆಕ್ಷನ್ ಇದೆ. Kindly see annexure A melo. Page number 18.
Learned AG takes notice for response number
1 to 3.
1 and 3.
1 and
Learned Counsel Shri T.L. Kiran Kumar is directed to take notice for response number 2 and 4. Issue notice to response number 5. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on Learned Counsel for response number 2 and 4 and a copy on the Learned AGA. Next para. Under similar circumstances, this court, while noticing the fact that no reasons are assigned to have placed the petitioners in the list of ineligible voters, permitted such petitioners to cast their vote and participate in the election. So, therefore, the fourth respondent, returning officer, is hereby directed to permit the petitioners to participate in the ensuing elections. Stop. However, the votes cast by the petitioners shall be kept in a separate ballot box, and the results of the elections shall not be announced without specific directions from this court. Yes.
ನಾಳೆನೇ this case, my lord, I am appearing for petitioner. Petitioner, my lord, working in Note Mudranalaya printing press, my lord, in Mysore, and she is working from like 23 years. Then, my lord, the petitioner mother, my lord, mother-in-law, my lord, is suffering from, my lord, she is suffering from various diseases and she is looking after, and her daughter is, my lord, studying at 11th standard, and husband is, my lord, suffering from dementia, my lord, problem. Then, my lord, the petitioner, kindly see annexure F for a moment, my lord. That is, my lord, annexure F. Page number 35. She has, my lord, called, my lord, for promotion. She has said, my lord, explaining reasons and producing documents that she don't want promotion because, my lord, she is working in Mysore and now she is transferred to, my lord, Selbonia, Calcutta, and, my lord, for by granting promotion. No, because of these reasons, my lord, that she has not opted promotion also. Kindly see, my lord, annexure here, my lord. No, she has been transferred. It has been decided that you should be transferred to Bharatiya Reserve Bank Note Mudranaya Private Limited, Selborne, in your existing capacity on long term basis.
Where is your representation?
Representation, my lord.
Annexure F.
Annexure F ಅಲ್ಲ, ಅದು ಪ್ರಮೋಷನ್ ಬೇಡ ಅಂತ ಹೇಳಿ ಲೆಟರ್ ಕೊಟ್ಟಿರೋದು.
ಇಲ್ಲಿದೆ
Annexure F. Kindly see annexure G, page number 38. With reference to the 6,038, annexure G. Interview for promotion of the post of manager. General manager, so and so, Mysore, that we have given this letter. This is annexure G.
I was advised to submit an undertaking that I have no objection to change in posting on transfer to another unit in the event of my promotion.
Yes.
In this regard, I wish to submit that I am unable to submit such an undertaking due to the reason that my cases of demotion, transfer, and promotion are pending. So I am unable.
Next paragraph.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ನೀವು that
I have completed 20 next
where have you said that I do not want a promotion?
Yes, kindly see next. I have completed 23 years of sincere and dedicated service to the
ಎಲ್ಲಿ
company.
ಓದ್ತಾ ಇದ್ದೀರಾ?
ಎರಡನೇ ಪ್ಯಾರ ಜೇದಲ್ಲಿ next year.
J
Third ಪ್ಯಾರ
page number
38 annexure J. I have completed 23 years of service and dedicated service to the company, being 4th rank holder in BE, so and so and so. If you consider my good service and personal problems and retain me at Mysore with promotion, I will be grateful to the company in my entire life. If it is not possible, I am ready to sacrifice my promotion for retaining me at Mysore. I assure you that
ಆಯ್ತು
I will.
ಸರಿ ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ಏನಾಯ್ತು?
ನೆಕ್ಸ್ಟ್ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಹಾಕಿದ್ರು.
ಸರಿ ಆಯ್ತು. Now they have promoted in, they have transferred.
ಪ್ರಮೋಷನ್ ಮಾಡಲಿಲ್ಲ.
ಹಾ ಮತ್ತೆ ಏನು?
ಹಾಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ಕಲ್ಕತ್ತಾಗೆ.
ಟ್ರಾನ್ಸ್ಫರ್
annexure M. Since I have said, my lord, I am retaining in Mysore, I will not undertake. Therefore, my lord, that they have not promoted me, since I want to retain in Mysore, then my lord, annexure M can be passed. In page number 41. It has been It has been decided that you should be transferred to Bharatiya Reserve Bank Note Mudra Private Limited, Selborne, in your existing capacity. Promotion kodlilla. On long-term basis, accordingly, you will be relieved from the office at the close of business on April 28th of 22. This is my lord. Lord, since my lord, I have produced a medical certificate of my husband and my daughter is studying.
That is not
criteria. Apart from that, I have served my lord 3 years in.
Please point out to the provisions of law, sir. If there is any regulations of theirs, you please point out to that one. ನೀವು ಈ ತರ submission ಮಾಡಿದ್ರೆ ಏನ್ ಬಂತು?
Once considering my lord these aspects, my lord, this honorable court has passed order.
You don't have your own regulations?
Regulations means, my lord, that Reserve Bank regulations, my lord, that transfer is.
That one then. ನೀವು ಅದನ್ನ ಬಿಟ್ಟು without any.
Yes. One thing. Service rules is there. There is no specific transfer. Transfer provision is not there, because my lord, there are only two offices.
Transfer is an incident of service.
Yes.
You can't say I cannot be transferred anywhere.
No, I'm not saying. No, I'm not saying.
Therefore,
my
please
humble.
point out to the regulations. If there is anything that could protect you, you please point out.
Kindly see in another, my lord, under these circumstances, my lord, kindly see page number 31D. Earlier, my lord, she has transferred, then they have withdrawn by virtue of giving my lord representation. Kindly see this order came to be. In the meanwhile, I'll see the provision annexure D in page number 31. Then kindly see they have in view of the withdrawal of the order of transfer. This is 2021 ಮೊನ್ನೆ ಆಗಿರೋದು.
ಹೌದು sir, but that was filed in the year 2017.
However, they have withdrawn that transfer order. And my lord, the no suddenly my lord
transfer ಮಾಡಬೇಡಿ ಅಂತಂದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ sir?
ಇಲ್ಲ ನಾನು ಹಾಕಿರೋದು condition ಹಾಕಿದೆ. Kindly for a moment annexure P. Then condition I'll see. Kindly one second. Rules may kindly see. Rule 11 may be. Rule 11. Rule 11. Sufficient reasons ಕೊಟ್ರೆ my lord, rule 11. ಅಲ್ಲ 11 ನನ್ನದು ಒಂದೇ ಕಾಪಿ ಇರುತ್ತೆ ಸರ್.
You don't even want to make out grounds, sir. Huh?
I'm extremely sorry, my lord, since
What is it?
that we have made a ground and see cause has been given representation which we have submitted medical certificates of my husband, my mother-in-law and daughter has been placed, and we don't want promotion. And my lord, that is not a compulsory as per service rules if cause has been shown. We have shown all the cause.
Nine point two ಹೇಳ್ತಾರೆ, an employee may be posted to any of the factories at Mysore or Salboni or at the corporate office or any factories, offices which may be opened in future or any of its associate institutions of the company as company may decide.
Hannandu.
That also will go against you, sir.
No,
It will be treated as abandonment.
Sufficient cause not ತೋರಿಸ್ತಾ ಇದೆ.
That cannot be sufficient cause. Last time also you have got a relief, sir.
I have worked about
ಮತ್ತೆ
3 years.
Which means you intend never to be transferred.
No.
ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ನೋಡಿ.
No, sir.
ನಾನು ಪ್ರಮೋಷನ್ ಆಪ್ಟ್ ಮಾಡಿಲ್ಲ. ನನ್ ಕ್ರಿಟಿಕಲ್ ಪೊಸಿಷನ್ ಒಂದ್ಸತಿ ಸಿನ್ಸ್ ಮಿಲಾಡ್ ಆಸ್ ಪರ್ 11 ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಐ ಡ್ರಾ ಯುವರ್ ಲಾರ್ಡ್ಸ್.
ಸರ್ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಒಂಚೂರು ನೋಡ್ಬಿಟ್ಟಿರ್ತಾವ.
No, sir.
Annexure P ಒಂದ್ಸಲ.
You have got the relief already once. It cannot be given again and again.
We are constrained, my lord. Since my lord, 3 aspects. My daughter, ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಹೋಗ್ತೀನಿ ನಾನು. ಇದೊಂದು ಚೂರು ಸಿನ್ಸ್ my lord, my mother-in-law and husband ಡಿಮೆನ್ಷಿಯಾದಿಂದ
ಆಗಿದೆಯಲ್ಲ ಸರ್, ಆಗ್ಲೇ 5 ವರ್ಷ ನಿಮ್ಗೆ 5 years relief has been given. How long can we give it?
ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಬಟ್ ಅಲ್ಲಿ ಅರ್ಲಿಯರ್ 3 ವರ್ಷ ವರ್ಕ್ ಮಾಡಿ.
Was filed in the year 2017.
I have stated I have worked there.
ಎಲ್ಲಿ?
ಸೆಲ್ಬೋನಿಯಾ.
ಅದಕ್ಕೆ
ವರ್ಕ್ ಮಾಡಿದೀನಿ ಅಂತ ಒಂಚೂರು ನೋಡಿ. ಸಿನ್ಸ್ my lord, I have made out a case under rule 11 to my lord substantiate my reasons has been assigned. This 2,500 ಕಿಲೋಮೀಟರ್ ದೂರ ಪರಿಸ್ಥಿತಿ.
They say an employee may be transferred without assigning any reason from one job to another, from one department to another, or from one office to another, or from one establishment to another establishment of the company now existing, or that may come into existence in future in any part of the country. In case of refusal of the employee to any transfer, such employee shall be considered to be absent from duty from the period of such refusal and shall not earn salary for the period of such non-reporting to the place of transfer. Such employees are also liable for disciplinary action.
Nanige, unless otherwise, my lord, ground which is there. This is not a beneficial post also, my lord. And since, my lord, there is no other reasons to, my lord, hold the transfer. Because sub-registrar mattun tahsildar deputy commissioner, that is different issue. This is, my lord, I am note ಮುದ್ರಣದಲ್ಲಿ my lord count ಮಾಡುವಂತ ಕೆಲಸ.
Sir, that is giving life to you.
ಅದು ಲೈಫ್ ಕೊಡ್ತಾ ಇದೆ.
ಈ ತರ ಮಾತಾಡಿದ್ರೆ ಏನು ಬರಲ್ಲ.
No, I am my humble submission.
You are surviving on this salary.
Absolutely, I agree with you, lordship. Kindly annexure P for a moment. ಒಂದ್ಸಲ ನೋಡಿ. Medical certificate which we have produced. Alla, my daughter.
For them to consider.
Alla, one second.
Not for this.
For a moment, my lord, kindly see. My daughter is 11.
Please go. Let her go and take charge.
12ನೇ ಕ್ಲಾಸ್ ಮುಗಿಸಿದ್ರೆ.
Let her go take charge and come back. We'll see.
ಅಲ್ಲ, ಅದಕ್ಕೆ one second. No medical certificate. 3 ಜನರ
charge. Apply for leave. Come back and prosecute this case. On protest.
One second. Annexure P. Annexure P. Page number 43. Medical certificate.
ಅದನ್ನೆಲ್ಲ ನಾವು ನೋಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್.
Equity ಮೇಲೆ
ಹೇಳ್ತಾ ಇರೋದು 5 ವರ್ಷ. You have already got the benefit. You can't ask for the same benefit again and again.
Again, because I have worked there also. Therefore, my lord, 3 ಜನರ certificate ಆಗಿದೆ. Under those circumstances, my lord, in case, my lord, the interim order granted, my lord, immediately after vacation, we will, my lord, in case if your lordship is considering, my lord, saying that I am not entitled ultimately.
No interim order. Learned counsel Srimati Tejaswini BR is directed to take notice for the respondents.
The report for notice issue ಮಾಡಿ delivered notice issue ಮಾಡಿ. Yes, if you are not giving the issue notice to respondent.
No, I will notice. I will permit the petitioner to go and take charge there under protest and apply for leave and prosecute the case. Otherwise, it is not possible. The learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent. Next para. Prima facie, this court finds that even on an earlier occasion, when an order dated 4/8/2016 was passed against the petitioner by the respondents, this petitioner had approached this court in WP number 21050 of 2017 and obtained an interim order against the transfer order. Stop. Subsequently, the order of transfer was withdrawn on 1/9/2021 and the petition was disposed of as having become infructuous. Stop. Now, once again, when an order of transfer is passed against the petitioner, the petitioner has filed this writ petition. Stop. Next para. This court is not inclined to grant interim relief to the petitioner. However, the petitioner may proceed to the place of transfer, report for duty on protest, and prosecute the matter in accordance with law. Full stop.
ಏನಾಗತ್ತೆ ಅಂದ್ರೆ ರಿಪೋರ್ಟ್ ಆಗ್ಬಿಟ್ರೆ ನಿಮ್ಗೆ ಅಲ್ಟಿಮೇಟ್ಲಿ
On protest, ಹೇಳಿದೀವಿ. But you are going to lose your salary.
Petitioner is appointed as the middle school science teacher, my lord, and she is assailing the transfer of it 12/5/2019.
You are arguing on what? You are arguing on what? Main matter or application? Huh? This is listed for orders today.
I am appearing for respondent in this
IA
matter.
for
bringing the additional facts.
additional facts.
Yes.
Amendment.
No, my lord.
Huh?
Additional facts since the
Additional facts, how do you bring? By amendment, isn't it?
yes, my lord.
Without amending, can you bring the facts on record? So you should have filed an application for amendment, isn't it? Even if it is for additional information that you want to place, but it should have been an application for amendment. Huh?
Yes.
Any objection?
My lord, that additional facts, my lord, that copy has not been served at all, my lord.
Tilva.
No, my lord.
Please
that
serve a
has
copy on the other side.
Yes, yes.
Learned
I have
counsel for the
already served
petitioner.
through RTA, my lord.
Huh?
I have served through RTA.
ಅವ್ರು ಸಿಕ್ಕಿಲ್ಲ ಅಂತಾರಲ್ಲ.
No, my lord, I am for R2 to 4, my lord. That additional facts IA is not. The other IAs, my lord, IA 1 stay and all is there, my lord, direction. That additional facts is not there, my lord.
ಯಾವ್ದದು ಅಡಿಷನಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಇದು?
IA 1 of 21.
1 of 2022.
20?
1, my lord, 21.
21 ನಾ 22 ನಾ
1 of 22.
22 ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ 21 ಇರೋದು. 1 of 2020.
I have filed on 25/1/2022.
That was not served, my lord.
The counsel for the petitioner is direct to serve copies of IA number 1 of 2022 on the learned counsel for the respondent. List this matter after summer vacation 2022.
Interim order can be kindly extended. There is an interim order.
Interim order granted earlier stands extended till the next date of this. Week's time is granted to the petitioners for furnishing the certified copy of annexure B. Annexures A and B.
Appear for R1 minute.
The notice has been served to respond number 2, my lord.
Respond number
Notice here.
respond number 2. Chairman.
Still as a
Oh. Appearing for respond number 1.
I appear for
So you will
respond number
take
1 minute.
you will take notice for respond number 2 also.
Well, not
Respond number 2.
This is not a necessary party, my lord. No orders are passed by R2. Simply he has been made a party. All the impugned orders or division bench
It's all right,
orders
sir.
are-
Sorry, you please take notice.
Okay, yes, my lord.
Learned counsel. See. SN Murthy ಅಂತ ಬರ್ಬಿಟ್ಟಿದಾರಲ್ಲಿ
ಅದೇ ತಪ್ಪು SN Murthy associates, my lord.
ಬರೋದಿಲ್ಲ.
Somshekar.
Counsel. Somshekar, who appears for respond number 1, he is requested to take notice for respond number 2 also. Office is directed to choose the name of learned counsel Shri Somshekar.
Yes, ma'am.
For both the respondents.
Please, ma'am.
Yes. Is this matter after summer vacation 2022?
24th May.
ಏನ್ 24th ವೆಕೇಶನ್ ಸ್ಟಾರ್ಟ್ ಆಗೋಯ್ತಲ್ಲ, ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ. ಸಿನ್ಸ್ ಯು ಆರ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್, ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 24th of May.
Much obliged.
ಸ್ಮಾಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಪಿನ್ ಕೋಡ್ ಬರ್ದಿಲ್ಲ ಅಂತ ಒಂದು ಹಾರಿಜಾಂಟಲ್ ಆಗಿ ಸ್ಟಿಚ್ ಮಾಡಿಲ್ಲ. That I will do it.
ಆಯ್ತು.
Petitioners, my lord, who are appointed, my lord, as watchman and archak of the temple, your lordship, in 2016, your lordship. And they were while discharging their duties, my lord, on the strength of the newspaper information, my lord, they were asked to be terminated by the officer, my lord. That was called in question, my lord. Could kindly see, my lord, the order passed, appointment order, page 33, my lord, page 33. Page 33 is the appointment order, your lordship, which was issued in favor of the petitions, my lord. Page annexure B, page 36. So these people duty is not one is archer, another one is watchman, your lordship. ಆ ಟೆಂಪಲ್ ಅಲ್ಲಿ ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ದೇವಸ್ಥಾನದ ವಿಶೇಷ ಏನಂದ್ರೆ ಜನ ಜಾಸ್ತಿ, ಅಲ್ಲಿ ಪ್ರಾಣಿ ಬಲಿ ಕೊಡುದು ಅದೆಲ್ಲ ಕ್ಲೀನ್ನೆಸ್ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ ಅಂತ. It is not doesn't come within their duty. However, on the strength of that general allegation made in the newspaper, we were removed from the relieved from the duty. Annexure B1, my lord, may kindly see. Annexure B1, page 39. I mean, then fault illa, general allegation published in the newspaper.
ಏನಾಯ್ತು? What happened?
Then, my lord, I challenged it before this honorable court, and this honorable court was pleased to grant an interim order, page 42, my lord.
Ah.
Subsequently, the assistant commissioner, what he did is, your lordship, he has convinced these petitioners, my lord, to withdraw the petition so that he can regularize his service, their service, your lordship. Based on that assurance given by the assistant commissioner, my lord, these people have withdrawn the writ petition with liberty to file a fresh writ petition in the event if they do not act according to that. Though there is a recommendation made, my lord, for consideration of the case of the petitions, my lord. However, the petitions continue to be in service, but their regularization was not being done. Now, my lord, the new assistant commissioner who has come in power, my lord, he says that, my lord, that since the order of relief, order which was not challenged before this honorable court was not set aside, that I am going to terminate. That's how, my lord, he has been threatening the petitions, my lord, to terminate. Therefore, petitions are before this honorable court. They have been discharging their duties, my lord. There is no. This honorable court was protected their interest, your lordship. There is no allegation against them, my lord. A general alleged statement of a newspaper. He is doing his duty. This another one watchman, he is doing his duty. People comes and celebrate their festival. ಈಗ ಅವರು threaten ಮಾಡ್ತಾ ಇದ್ದಾರೆ ರಿಲೀವ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ. That's why we approached this honorable court. The new assistant commissioner has forgotten the ಅದು ಮೊದಲು recommendation ಅಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ. ಮಾಡಿದ್ರು ಸಹ I am not concerned, I am going to relieve her because earlier order has not been set aside by this honorable court ಅಂತ ಹೇಳಿ. Orally it was informed to the petition. Therefore I was constrained to file this petition.
You are not permanent employees.
No, ತಾತ್ಕಾಲಿಕವಾಗಿ ಮಾಡಿದ್ದು 2016 ಇಂದ I have been discharging it. ಅವ್ರು ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ರೆಕಮೆಂಡೇಶನ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲಿ ದೇರ್ ನೀಡ್ಸ್ ಎ ಅರ್ಚಕ್ ಅಂಡ್ ದಿ ವಾಚ್ಮನ್ ಅಂಡ್ ಅಟೆಂಡರ್ ಅಂತ. ಆದ್ರೂ ಸಹ ರೆಕಮೆಂಡ್ ಮಾಡಿದ್ರು ಸಹ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ. ಬಟ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್, ಪ್ರೆಸೆಂಟ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಇಸ್ ಥ್ರೆಟನಿಂಗ್ ದಿ petitioner that he is going to terminate. It is in that background the petitions are before this honorable court. Interim order was there, my lord, throughout the petition. And subsequently, the case of the petitioners were recommended in all the stages by the then assistant commissioner also, who has assured that their case will be regularized.
What is the immediate
Threat is relieving order na effect ಕೊಡ್ತಾರೆ. Relief order which was stayed by this honorable court, my lord, which was issued in 2017, my lord, which was stay was in operation, my lord.
How can they give effect to that one now?
No, but that's what they say. That's what they say. That's what they say. These people are archak and watchman. The temple. Samudrai temple. ಸ್ವಚ್ಛತೆ ಕಾಪಾಡಿಲ್ಲ ಅಂತ ಸ್ವಚ್ಛತೆ ಕಾಪಾಡೋದು ಅರ್ಚಕರು ಮಾಡುದಲ್ಲ, ಬೇರೆಯವರು ಮುನ್ಸಿಪಾಲಿಟಿ ವ್ಯಾಪ್ತಿಗೆ ಬರ್ತದೆ. ಆ ಕ್ಲೀನ್ನೆಸ್, ಸರೌಂಡಿಂಗ್ಸ್ ಆಫ್ ಟೆಂಪಲ್ ಎಲ್ಲಾನು ಕ್ಲಿಯರ್ ಮಾಡುದು. This honorable court was pleased to stay the operation of the relief order.
And the additional deputy commissioner also has recommended.
ಎಲ್ಲ ರೆಕಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ, but still you will be relieved ಅಂತ ಹೇಳಿ ಥ್ರೆಟನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. That is the reason otherwise I would not.
There is nothing on record.
So, except they are going to relieve order, which is now there.
Where is any material to show that they will revive that order? Any material?
Orally they are saying you. Orally they are saying you. Let them say before this honorable court that they are not going to take any action. I will be happy, my lord. I will be satisfied.
Let them come. See.
Let them say, my lord.
Learned AGA takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned AGA. Full stop. Next para. Although learned counsel for the petitioner submits that in the earlier round of litigation, there the petitioners had raised a challenge to
Relief order issue.
The relief order dated 19/6/2017
14/6/2017. There are 2 orders.
and 14/6/2017 14/6/2017 and 19/6/2017. There was protection to the petitioners in WP number 28672 of 2017 till the petitioners withdrew the writ petition on 5/2/2020, on the assurance given by the respondent authorities that the case of the petitioners for regularization of their services and payment of arrears of salary would be considered if the writ petition is withdrawn. Nevertheless, the authorities are now threatening to implement the earlier orders dated 14/6/2017 and 19/6/2017. So, nevertheless, there is no material placed on record to convince this court that the earlier order dated 14/6/2017 and 19/6/2017 will be implemented at this point of time. Stop. Next paragraph. Nevertheless, the respondent authorities are hereby directed not to precipitate the action till the next date of hearing.
Pursuant to the order dated, Your Worship. Pursuant to the order dated.
Yes, sir.
For respondent, I case 1 week time. Like instructions, your one officer
Petition will become infectious, my lord.
Yes.
Petitioners are employees of the BESCOM Davangere division, my lord. They have already put in 25 years of service, my lord. Now they are currently in the cadre of meter readers, my lord. They are to be given promotion to the cadre of junior engineers, my lord. The criteria is that, my lord, they should have put in minimum 15 years of service in BESCOM, and out of which 5 years as meter readers they should have completed, my lord. In fact, the petitioners have put in 25 years of service, my lord, and they have completed almost 6 to 7 years as meter readers. The only hurdle what they are having is KEB R&P regulations prescribes. Department should have given training to them to get the eligibility. They have not given promotion. They have not given this training. From 2020, we have been approaching, my lord. Due to no fault of ours, my lord, we have not been given. And contrary, my lord, other employees, my lord, who were way juniors to the petitioners here, my lord, they have been given, one batch of employees have been given training, and they have been placed over and above the petitioners in the seniority list, my lord. And the respondent authority is in the process of giving promotions to them, my lord. If that happens, my lord, ಮತ್ತೆ promotions ಆಗಬೇಕು ಅಂತಂದ್ರೆ ಆ slots ಖಾಲಿಯಾಗಿ
where is the seniority list?
Lords may kindly see which is at page number 22, my lord, annexure C. Relevant pages are at page number 25 and 26, my lord. 25. Now your lordship may kindly see date of entry into service.
Where does it start? 20?
From 25, my lord. 25, my lord. Page number 25, my lord.
When was this published?
Lord, 8th February 2022, my lord.
Huh?
8th February 2022.
Where do you get this?
Which is at page number annexure C, my lord. Page number 20. Page number 22, my lord. Annexure C. Annexure C, my lord. Page number 22, my lord. They have published the seniority list of several employees. Out of that, my lord, fourth category, operator, male vicharakara, mapaka, odaga, Urdu is coming, is forthcoming, and I have produced the relevant lines, my lord, relevant pages, my lord. I draw God's attention to page number 25, my lord. 25, my lord. Your lordship may kindly see date of entry into service. Melgadenalli. Date of entry into service. Your lordship may kindly see serial number 3 in the Swami. They are all appointed as in the year 2007, 2008, my lord, and 2009 as well, my lord. Now let kindly turn to next page, my lord. Next page, my lord. Next page, date of entry into service. These employees are appointed in 97 and 98.
Serial number.
From serial number 27 itself, my lord. And the petitioners who have filed this petition are marked, my lord. Serial number 29, 34, 35, 36, 37. You know, the date of entry to service is all 97 and 98, my lord. In spite of they having served 25 years of service and more than 6 to 7 years as meter readers, my lord, the department has not given training to them, which was supposed to be given by them, my lord, which is nomenclated as MPTP2 training, my lord. Now we launch like NTC in the serial number 3 to serial number 26. These employees have been given training, and these employees, since they have conforming to the criteria for being promoted to the cadre of junior engineers, my lord, the department is in the process of giving promotions to these employees, overlooking the seniority of the petitioners here in the lordship. Kindly say petitioners, some of the petitioners are 58 and 58.
Date of order of appointment,
Yes, my lord.
promotion, ICT to the present post. They're all on the same day, 16th of January 2016. They're all on the same day, sir. If you are not aggrieved at that point of time, how can you raise a grievance now?
May I draw the court's attention to the KEB R&P regulations, which is at page number 18, my lord, Annexure B, my lord, for a moment, my lord. Seniority list is of the year 2000, February. Page number 18, my lord, Annexure B, my lord. This is KEB R&P regulations, my lord, which lays down the criteria, my lord. Page number 18, my lord. Your lordship, I can see next page, my lord, which is at page number 19, my lord. 19 ali, B, my lord, 17.5% of posts by promotion of non-technically qualified overseas. These the employees here are the non-technically qualified employees, my lord. Now the criteria, my lord, the conditions that they have to meet to get promotion is in case of non-SSLC, SSLC meter readers who have undergone training conducted by the board. This is the criteria, my lord.
Yes.
In fact, they have not been given training by the board, and since they have not received training, my lord, the employees who have received training and who have already completed 15 years and 5 years.
Not only training, sir. You should have passed the test.
When they have not given.
Adhe ಓದಿ. ಪೂರ್ತಿ ಓದಿ. ಏನ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
Training is also not given for us.
ಏನ್ ಮಾಡಕ್ ಬರುತ್ತೆ?
Training is given, my lord.
You have kept quiet all along.
No, my lord.
When training was being given to the other persons, why did you keep quiet, sir? 2016, they have been declared as having passed the test.
No, my lord. In 2016, my lord, they have been promoted to the cadre of meter readers, my lord.
Sir, we can't issue directions contrary to the regulations.
No, my lord. No, this is not contrary to the regulations, my lord.
You have pointed out to the regulation now.
Regulations.
You have pointed out to the regulation, which says that is the minimum requirement. If you have not satisfied that requirement, how can we direct them?
My lord, passing test is a formality because, my lord, if I have given training, my lord, I should be given test, my lord. When I am not given training at all, my lord.
We'll only say if they are promoted, it will be subject to the final outcome of this petition.
I have not been given training, my lord.
Yes.
My lord, I appear for the respondent. My lord, the seniority list has not been challenged till date. Even in this petition, nothing has been challenged.
Sir, the seniority list is of the year 2022. You are not challenging that one?
No.
You are not challenging that seniority list here? You not raise the challenge to the seniority list?
Lord, I have given the sort for mandamus, directing the respondent authorities to give training to us.
Sir. You are conceding then. You will be conceding then. If you say direct them to give a training now, you will be qualified only after training and passing the test.
2022, my lord. The reason why I was not given training, my lord, is that, my lord, the department mistakenly considered us as technically qualified persons. That anomaly is not corrected, my lord. We come under non-technically categorized persons, my lord. We were supposed to be given training, my lord. Due to no fault of ours, my lord. Your lordship, I can see some of the petitioners are 58 and 59, my lord. They are not given training at this point of time, my lord.
It is evident from the material available on record that the petitioners have not undergone training conducted by the board, nor have they passed the test.
Training is not given to us
at the end of the training, which is required in terms of the
regulations. Training is not given to us, my lord. And the hands of the respondent authorities.
Karnataka Electricity Board Recruitment and Promotion Regulations. Dash employees, bracketally probation, close. Regulations and employees, bracketally seniority, close regulations. As found at Annexure P. So, the petitioners have also not challenged the seniority list. Prepared and published on 8th of February 2022 at Annexure C. Therefore,
this is a temporary provisional seniority list.
If the respondents go ahead with the promotions in terms of the seniority list, comma, the same shall be subject to the final outcome of this writ petition.
But this is temporary seniority list.
Temporary, provisional seniority list.
In the meanwhile, my lord, they may be directed to consider the representation, my lord. I am representation with Annexure A, my lord.
Yeah, no, for what? For training.
For training, my lord.
But what is the use?
In spite of
In the meanwhile,
Then, my lord,
the respondent corporation.
Writ petition itself could be disposed of, my lord, to consider this representation.
No. But they are saying the promotions could not have been given. If they want to challenge it, let them challenge. But of course, there is no sufficient grounds.
Yes.
To not even challenge the provisional seniority list.
No, I am at the mercy of the respondents, my lord. I have given several representations.
Sorry, sir. When you admit that you have not undergone the training, what can we do?
They have not given us training, my lord.
Sorry, if we direct them to give you training, can we dispose of the matter?
And till the training is given, my lord, then promotions will not be given, my lord. Because, my lord, this will haunt me for the rest of my life.
In the meanwhile, the respondent corporation is required to consider the representations given by the petitioner for giving training to the petitioners.
Within 1 month, my lord. In fact,
yes.
Because, my lord, your lordship, some of the petitioners are 58 and 59, my lord. If they are not given timely promotion, this will haunt them for the rest of their life.
You have been sitting quite for a long time, sir.
With your lordship's kind leave, my lord.
Yes.
Lord, this is a case wherein a disciplinary proceedings has been initiated against the petitioner while he was in service. And he has been suspended from duties for nearly 9 months and suspension has been revoked. During the inquiry proceedings, my lord, the inquiry officer has.
So there is no interim relief. There is no interim
There
relief.
is no interim relief, only writ of madam, Mrs. Swami.
Learned
One
AG
small objections is there.
takes notice for all the respondents. Learned counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned AGA. Next para. In the meanwhile, office objection should be complied with.
Very good. That's all I had to correct.
So, serial number 14 and kuda. In the meanwhile, office objection should be complied with.
Much obvious.
No.
Cases come up on 4 objections. One is the original copy of the annexure for washing, for which I filed a dispensation. One more, the date, there seems to be some confusion. I'm seeking for quashing of the final list, annexure D. Page number 30.
You have to comply, sir.
I've sought for some interim relief in the meanwhile.
Yeah, no, what is the interim relief?
Interim relief is staying the operation of annexure D, which is the final list one. The case of the petitioner is that Karnataka government has abolished Group C and D interviews for the post of Group C and D. Despite that, interview was conducted in this particular examination, after which she has lost out on getting the post of First Division Assistant. Examination for First Division Assistant post of conducted by the Karnataka State Consumer Cooperative Federation. Page 47 has the final consolidated marks. Petitioner serial number 2, Bhagya by CK. In this, it's seen that she has received the 151 marks.
Sorry,
but has received less marks in the interview, because of which she has not been able to secure the post of first division assistant.
where is that notification issued by the state government?
That notification, if you pass over, my lord, I was able to procure it. Just in the morning, I have received that notification. The draft notification was there, but the final notification is 2021 March notification.
When was this interviews conducted?
Interview was conducted in October of 2021.
Then when was that notification issued?
March 2021. This before this notification was issued, the government notification came to be issued.
You have,
the 5th of March 2021.
but you have not said so in your grounds.
I have mentioned the draft notification, but I have just received the final notification copy. In view of the central government notification, state government in 2021-20 issued draft notification for cancellation of interview for entry-level posts. On 5/3/2021, the final notification came to be issued. Karnataka Civil Service Direct Recruitment General Rules of 2021.
Where have you said in your ground?
In the ground, I've mentioned the draft notification. Page. Paragraph 8. That was a draft. The final notification, I just received the copy. I can produce it with your lordship.
Annexure F.
No, that notification copy ಇರಲಿಲ್ಲ.
ಅಲ್ಲ ಇದು annexure F ಅಂತ ಹೇಳಿದೀರಾ ಮತ್ತೆ ನೀವು? In paragraph number
Annexure F is the central government notification, subsequent to which the state passed notification. Annexure F is the central government notification.
State government ಏನು ಹೇಳಿಲ್ವಾ ನೀವು?
Ali, I've just mentioned the notification number and
8/7/2020.
Please, I'll produce the final notification. I've received that just in the morning. ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
Learned AGA takes notice for response number 2. Issue notice to response number 1 and 3. Learned counsel for the petitioner is direct to serve a copy of the petition along with annexures on the learned AGA. Next para. Learned counsel for the petitioner submits that consequent to the Ministry of Human Resources Development, Government of India issuing a notification dated 19/5/2017 directing
9/5
19/5 ಅಂತ ಬರ್ದಿದ್ದೀರಾ? 9/5
9/10/2015
ಎಲ್ಲ ರಾಂಗ್ ಬರ್ದಿರಲ್ಲ.
ಟೈಪ್ ಕಾಪಿ ಪೇಜ್ 50.
ಪ್ಯಾರಾಗ್ರಾಫ್ 8 ಅಲ್ಲಿ ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ಎಲ್ಲಿದೆ? ವೇರ್ ಇಸ್ ದಟ್? Annexure F.
Page 50.
Dated 9/10/2015. The government of Karnataka also issued a draft notification dated 8/7/2020 directing discontinuation of the requirement of conducting interviews while recruiting persons in the junior level posts, namely Group C and D, Group D and C. Stop. Nevertheless, the first respondent who was entrusted with conducting the recruitment process for the post of First Division Assistant. First Division Assistant. Has conducted interviews, and it's only because of the marks given in the interviews that the third respondent was able to secure appointment. While it is clear from the marks obtained in the qualifying examination, the petitioner had scored 151 marks, while the third respondent had secured 149 marks. Stop. Appointment agogidiya?
Charge.
Nevertheless, the third respondent has already been appointed. Stop. Therefore, the appointment of the third respondent shall be subject to the final outcome of this petition. Expera. In the meanwhile, office objection should be completed.
For the petitioners in this matter, my lord, some objections are clear them, my lord, but interim relief is being sought for. The petitioners, my lord, are daily wage workers, my lord, of Canara Bank. They've been working since 2010 onwards. Various periods they started employment and they're continuously working till now. The threat now, my lord, is that the bank has informed them that it's going to be outsourced and it's going to be issued on tender. Tender notice has also been issued, my lord. Now, what has happened, my lord, is that we have been employed, we have been giving glowing recommendations, my lord, from the bank at various stages. My lord can, for example, turn to page 40. As in respect of petitioner number 3. Annexure P, my lord. Each of them have such documents, my lord. Each of them have such similar documents. 9 petitioners are there. This is petitioner 3. Absorbing into our bank panel, Mr. Yatish Kumar, daily wages duty of attender, come part-time sweeper. With reference to the above, we are forwarding the application so and so for absorbing. We wish to bring a few following lines for due consultation. Our Hillier branch is opened in March 2013, and since then, no part-time sweeper regular attender is posted to this branch. And from the beginning of the branch, Mr. H. Yatish Kumar is discharging both the duties of part-time sweeper come attender duties, apart from any other work discharged allotted to him, like assisting in clearing house, recovery, SMA, canvassing new CASA deposit, Jan Dhan schemes in Disha, etc. His style of work is very neat, fast, and no much supervision is needed. Mr. Yatish Kumar is physically handicapped and belongs to SC Bodhi community. He may consider his application. My lord, similarly, all of them are SC, ST, OBC, my lord. Supreme Court, similar matter, my lord.
Now, what are they doing?
They are all doing attender job.
What is the respondent proposing to do?
My lord, the document, my lord, is that sorry, my lord, AY, page 95. There's the inter-office memo, my lord, to be issued, saying that all branches coming
engaging of unauthorized personnel in branches.
This is in respect of Bangalore Circle, my lord.
Yes.
In view of the above, all branches coming under a circle are instructed to send confirmation report to us by tomorrow. That is on 10th.
No unauthorized engagement of persons by branches officers shall be allowed under any circumstances contrary to the above, the concerned branch in charge section in charge shall be personally held responsible for such unauthorized engagement.
Then after that, the next page is the Bangalore Circle, my lord. Next page is for Davangere Circle. One email has been issued.
Correct, madam. How can we prevent them from implementing the provisions of the statute or the regulations?
Not statute, my lord. What they're doing, my lord, is unfair labor practice. What they're doing is they're exchanging us, daily wage workers. They're going to be exchanging.
They are saying unauthorized. If they are wanting to appoint some other persons on the same in the same terms, that temporary, casual, daily wage,
exactly, my lord.
That will be unauthorized again.
My lord,
I don't think that is the intention of this.
I'll submit two submissions, my
Yes.
lord. First is Annexure K may be seen, my lord. Page number 34. Several of them have such tables, my lord. Annexure K, my lord, please. My lord, may I take my lord to the Rajasthan High Court judgment? Similar case, my lord. Just give me 2 minutes, my lord. I will try
Appears
and
for this Canara Bank. Learned Counsel Shri T.P. Muttarna is directed to take notice for the respondents. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the Learned Counsel for the respondents. Full stop. Next para. The grievance of the petitioners who are admittedly daily wage employees is that by virtue of the impugned inter-office memorandum dated 9/3/2022 issued by the Chief General Manager, Human Resources Management Section, Bangalore, the respondent bank may discontinue the services of the petitioners as it is stated in the memorandum that no unauthorized engagement of persons by the branches or officers shall be allowed under any circumstances. Full stop. Next para. However, it is made clear that until a recruitment process is initiated by the respondents to appoint personnel in accordance with law, the services of the petitioners shall not be discontinued.
Last annexure, my lord, is a DA. They have issued tender notices. So they're going to replace this with contract workers. So for regular recruitment, that is sufficient, my lord.
Where is that?
That is at PA, my lord, at page 97. In that respect, Pyara Singh and other judgments of Supreme Court are there, my lord, saying that you can't replace one ad hoc worker with another temporary worker. Page 97, my lord.
Tenders for housekeeping.
Housekeeping and general cleaning works.
It is also made clear that the notice inviting tenders issued on 8/3/2022 is contrary to the regulations of the respondent bank, the bank will be precluded from appointing, taking the services of another set of temporary employees, since replacement of one temporary employee with another temporary employee will be contrary to the law declared by the Honorable Supreme Court of India in the case of State of Haryana versus Pyara Singh.
to SC2130.
AR
1992 SC2130. I'll comply.
Next para, in the meanwhile, office objections shall be complied with.
Respect to office of selection, comply the same. Item pertains to BBMP interest. Your Lordship's order is at page number 87. Next. Investment order is at page number 37.
But this person is the executive engineer. Who is the appointing authority? Who is the appointing authority in respect of executive engineer? If it is the state government, then he will come under the control of the state government. All the other cases were in respect of AWEs.
But however, Lords, the impugned articles of charge.
Sir, it depends on who is the appointing authority.
Lords, that is
if the appointing authority is the state government, then the state government has the power. The declaration made in the division bench decision is in respect of persons who are appointed by the commissioner of the corporation or any other officer.
However, one more aspect.
Therefore, the question is, who is the appointing authority in respect of executive engineer?
However, Lords, as per the division bench judgment, they said that the CCR rules would be applicable only for government servants and not public servants.
Sir, please understand the question. Who is the appointing authority for an executive engineer? If the appointing authority is the state government, then the state government has power. Pass over. I think there is one more. List agidi ante adu. Mone avaru Udayawalla avaru bandidralla. I directed matter to be listed today. Alva. Anyway, pass over. Yes.
Office objection is that certified copy of the impugned orders has to be produced by us. Liable dispensation. Identify liable dispensation. Matter is that, my lord, sir. The CCR, under the CCR rules, my lords, rule 14A, the matter has been entered into local for inquiry. The petitioner being the employee of the Karnataka Minorities Development Corporation, it does not come within the purview of the government servant. Therefore, my lord, sir, the order of entrustment by the government is the bad in law.
Where is your appointment order? Same thing will apply to you also. Huh? You will have to say who was your appointing authority.
Director of the Karnataka Minorities Development Corporation.
Where is that? Where is your appointing appointment order? Yavaga? Huh?
We have taken up after vacations.
At the request of learned counsel for petitioner, list this matter immediately after summer vacation 2022. Full stop. In the meanwhile, office objection shall be complied with. Yes.
The petitioner is working as a teacher in the court before the court respondent, my lordship, from 2012. Now they are removed from the service, my lordship. After filing this petition, they have removed from the service, my lordship.
Why did you file this petition?
And 2021, my lordship, 15 September 2021, my lordship. Now only it is numbered.
Alama, why did you file this writ petition?
Seeking mandamus to consider as representation, my lordship. To come under the grant in aid, because working as a teacher, but is not approved this post.
Now he has been removed from service.
Yes, my lordship.
Then this, you'll have to file a fresh petition.
Yes, my lordship.
The counsel for the petitioner submits that although this writ petition was filed with a prayer to direct response number 2 to 4 to representations dated 3/8/2021 at annexures G and H given by the petitioner for consideration to bring the post that the petitioner is holding in the fourth respondent institution under the purview of granting aid. Nevertheless, during the course of these proceedings, the petitioner has been removed from the services of the fourth respondent. Stop. Next para. Consequently, the prayer made in this writ petition has become infructuous. Stop. Therefore, the writ petition stands disposed of, granting liberty to the petitioner to raise a challenge to the subsequent order of dismissal.
But the petitioner is an employee of the third respondent company. It is a subsidiary units of the second respondent. Not the HMT Limited, Milord, is the main principal unit, has got the 4 to 5 subsidiary units, Milord, where the age of retirement has been from 58 to 60 in all subsidiary except the HMT Limited and the other things. Now HMT watches is closed. And HMT International adopted the 58 to 60 arrangement. Only to the HMT machine tools, Milord, that the age of relaxation from 58 to enhancement from 58 to 60 has not been implemented or brought into the amended in the standing order. Therefore, Milord, the set of the question has been raised in the earlier petition where it has been negative that it cannot be given the same similar benefits to the HMT machine tools. Be that whatever it is, Milord, now that the HMT machine tools, in order to give a benefit to the employees, a scheme came to be formulated extending, retaining a 10% of the workmen or any employees within a given financial year. Whoever retires in a given financial year, a 10% of the employees or the workmen will be retained from 58 to 60.
How do you decide this 10%?
That is the scheme came to be formulated, Milord. The annexure K might be looked into, Milord.
Page number?
Page number 39, Milord. Annexure J is an approval from the 38 is an approval to cabinet. May I turn to page 38, Milord? Annexure J. The Cabinet Committee on Economic Affairs today approved finance.
Sorry.
D is empowering the board of company to increase the age of retirement 58 to 68 to the extent of 10% of employees retiring in any year in relaxation of MPA guidelines. In this regard, would be formulated. Annexure K is the scheme came to be formulated.
In case of exceptionally skilled, professionally qualified, technically qualified employees working in critical areas to an extent of 10% of retiring employees in a financial year as per CCEA approval.
Therefore, Milord, that a scheme is direct workman working in critical areas, so on, so Milord. The guidelines has also been issued.
This was issued in the year 2015 itself.
2015. Every year they have to announce in a two phase, Milord. One is in 1st of April, another is on the 1st of September. In a given year, whoever has retired has to be shortlisted. They sent for a notification that whoever can opt or the unit chief can recommend that make a shortlist, recommend the employees whoever works in a critical area or necessity to be retained. That the shortlist has to be done in a two-phase in every year. That has not been done so. From 2016 or 17, it has been declared. 17 or 18, it is declared. From 17, 18, Milord, that no shortlist, no nothing is being given to the only to a pick and choice only in the officer grades, Milord. So far as to the general manager and them DGM to that level, they have extended the benefit without even notifying or with whoever wanted to opt or make a list, short list. There is a clear guidelines, Milord, and in general conditions, Milord,
It is not that I make an application. It is they have to formulate a scheme of whoever the retirement employees on the given year.
How can we direct them to continue, sir?
Kindly look into the general conditions, my lord. No, that has not been done so. I have been deprived of that benefit, my lord, not even to the non-me, for any other employees also, in a given year.
My lord, last year you should have moved them.
Because the retirement,
What can we?
now they have issued annexure L.
Now it is not possible to
Intimating letter that I am retiring in the month of the end of this month. Annexure L may be looked into.
My lord, may
appear for HMT. ನೀವಿದ್ದೀರಾ?
ಇದು my lord, similar
or ಮಾಡಿ ಶಾರ್ಟ್ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಪರವಾಗಿಲ್ಲ.
ಹೇಳಿ.
Similar matter has been, one more matter has been filed before by the same person, and ಅದರ ಮೇಲೆ ತಾವು ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿತ್ತು, ಅದರ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಮಾಡಿದ್ವಿ, ಅಗೇನ್ ಅದನ್ನ ರಿಮೈಂಡ್ ಮಾಡಿದ್ರು. ಹಾಗಾಗಿ both the matters let be connected, my lord. WP 31206 of 19 ಅದೂರು ಸೇಮ್ ಇದೆ. ಏಜ್ ಸೂಪರಾನ್ಯುಷನ್ ಆದ್ಮೇಲೆ they have claimed again
same person
ಅಲ್ಲ, other person same other person but same department. WP 31206
of
2019, my lord.
What has happened? Any interim orders?
Interim order ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿತ್ತು, ಅದರ ಮೇಲೆ we have charged before the in writ appeal 3025 of 19 3025 of 19 writ appeal. ಅದರಲ್ಲಿ again ಆರ್ಡರ್ ಅಮೆಂಡ್ ಮಾಡಿ ಮಾಡಿಫಿಕೇಶನ್ ಮಾಡಿ ಮ್ಯಾಟರ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಮೈಂಡೆಡ್.
ಏನಂತ
ಸ್ಟೇ ಕೊಡಬಾರ್ದು ಅಂತ, ಸ್ಟೇ ಮಾಡಬಾರ್ದು ಅಂತ.
ಅಂದ್ರೆ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು,
ಮಾಡಿಫೈ ಅಲ್ಲ, ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ದಾರೆ. ಹಂಗಾದ್ರೆ
ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ದಾರೆ, ಅದು ಕಾಪಿ ಇರ್ಲಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಬೋತ್ ದ ಮ್ಯಾಟರ್
scheme is not being challenged in any of the petition. I don't know.
MS Narayan has entered appearance for response number
226, my lord. I have filed K-Wait for 6. ಮಿಕ್ಕಿದವ್ರಿಗೆ ಅಂಡರ್ಟೇಕ್ ತಗೊಂತೀನಿ ಸುಮ್ಮನೆ. I'll file the ವಕಾಲತ್ to them.
I filed the K-Wait.
K-Wait file
on behalf of respondent number 6.
Yeah.
The joint general manager. However, Learned Counsel submits that he would take notice for response number 225 also.
225 also.
Learned Central
also.
Government Council.
6 also.
K-Wait ಹಾಕಿದಾರಲ್ಲ ಸರ್. Learned Central Government Council is directed to take notice for respondent number 1. Learned Council ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ ಅವ್ರಿಗೆ?
ಒಂದು
ಸರ್ವ್ ಮಾಡಿದ್ವಿ.
Learned Council for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the Learned Central Government Council, and one more set on the Learned Council for the other respondents. Next para. Learned Council for the petitioner submits for the respondents submits that under similar circumstances in WP number 31406 of 2019.
My lord, 31206.
31206. 206
of
2019. This court had granted interim orders not to relieve the petitioner. However, in an appeal filed on the interim order before the division bench, in writ appeal number 3025 of 2019, the order passed by the learned single judge was modified but set aside. Therefore, Learned Counsel for the respondents would submit that this matter may be taken up along with WP number 31206 of 2019. Next para. Is this matter along with WP number so and so.
Hopefully that is not in so far as to 10% scheme.
ಅದು ಏನಾದ್ರೂ ಆಗ್ಲಿ ಸರ್.
ಅದರದ್ದು ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬಿಟ್ರೆ ಯಾಕಂದ್ರೆ ನಂದು 58 to 60
there cannot be a direction.
I am not questioning 58 to 60. I am not questioning the challenging the order of the enhancement of 58 to 60.
ಸರಿ, unless
I am challenging only the 10%.
ಗೊತ್ತಾಯ್ತು. We can only direct them to follow the scheme and give that benefit. But without without that being done, how can we direct them? If you want to dispose of the matter, we will dispose of the matter.
ಅಷ್ಟೇ ಅದೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬಿಟ್ಟು ನಂದು ಯಾಕಂದ್ರೆ 30ಕ್ಕೆ ನಾನು ರಿಟೈರ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದ್ದೀನಿ. ನಂದು ಸ್ಕೀಮೇ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ
ಕರೆಕ್ಟ್. ಅದು ಅಷ್ಟು ಬೇಗ ಆಗೋದು ಇಲ್ಲ. There is only hardly how many days?
58 to 60 ನಾನು ಕ್ವಶನ್ ಮಾಡಿಲ್ಲದೆ ಇರೋದ್ರಿಂದ that cannot be tagged along with that. And 58 to 60 is not a relief for me. My relief is only to extent of the 10% scheme. ನನಗೆ ಬೆನಿಫಿಟ್ ಸಿಕ್ಕಿಲ್ಲ ಅಷ್ಟೇ. ನಾನು 10% ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಇದ್ರೆ I would have continued 2 years for me. 30 ಆದ್ಮೇಲೆ ಏನಾರ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಅಂತ ಅಂದ್ರೆ it is of no consequence. And 58 to 60 ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ರೆ ಅದರ್.
Yes, what do you say?
58 to 60.
Why have you not followed that scheme?
My lord, I want to get my instructions. Both the matters are same, similar matters. That was the instructions, my lord. After vacation, it may be called.
No, but why have you not followed that scheme?
We are following the scheme, my lord. That is the instructions.
The learned council is on record saying that it has not been implemented from 2017.
There is no. Actually, there is no work at all. Since that is the case, they are not following.
There is only a direction, even under the scheme, only for 10%, for retention of 10% only.
Consider ಮಾಡಿಲ್ಲ ಬೇರೆಯವರು ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂದ್ರೂ ಸಾಕು ನಮ್ದು. I am outside the court.
ಅದು
ಅಷ್ಟೇ ಕೇಳ್ತಾ ಇರೋದು ನಾನು.
I want to get instruction or make
10% ಸ್ಕೀಮ್ ಅಲ್ಲಿ ನಿಮ್ಮನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ಬೇರೆ ಯಾರಿಗೂ ಕೊಟ್ಟಿದ್ದೀವಿ ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು. I am out of the court. I am not questioning the selection process also. Selection process question ಮಾಡ್ತಾ ಇಲ್ಲ. All that way I am entitled to be benefited because my lord kindly look into Annexure M, which my critical area of my service is required. I have been transferred to Chennai. Though I am retiring in 30, I have transferred to Chennai. Kindly look into Annexure M, my lord. Whether my requirement is there or not, another question.
Yes.
My lord, what has happened here is
last paragraph
work ಮಾಡ್ತಿರೋರಿಗೆ payments ಮಾಡ್ಲಿಕ್ಕೆ ಅಲ್ಲಿ salary. That is it is in a sick condition, my lord. HMT.
one ನಿಮಿಷ
before the division bench, WP number 2019. The final single judge was modified for set aside. Stop the report. This one could submit that this 06 of 9.
Last sentence. Sir, however, then a counsel for the petitioner submits that the grievance of the petitioner is that although a scheme was formulated by the respondents, in terms of the directions issued by the government of India, and scheme was announced as on 8/9/2015. To enhance the age of retirement from 58 years to 60 years in the case of exceptionally skilled or professional qualified or technically qualified employees working in critical areas to an extent of 10% of retiring employees in a financial year as per CCEA approval, nevertheless, from the year 2017, the scheme has not been implemented by the respondents. So, therefore, the learned counsel for the petitioner submits that a direction
2019.
Huh?
2019.
2019 17 ಬೇಡ 2019 Huh? Huh? Huh. So this petitioner was called.
Procedure ಇವಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ I am out of the court. That is my case is they have not called me. ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅಂದ್ರೆ that I am
All. Next para. However, it is contended on behalf of the respondent HMT that the scheme has been followed, and accordingly, those entitled for retention as per the scheme have been called for interview. Stop. Next para. Is this matter on 26th of April 2022 before the vacation bench to enable the respondents to place on record the information regarding the following of the scheme. Stop. Yes.
My lord,
You please place all that information. Yes.
yes, my lord, at least 29th, my lord.
Huh?
29th, my lord. 26th, 29th.
28th. You want it on 28th?
28th, my lord.
28th.
28th.
Yes.
for consideration of interim.
Yes.
Sir,
the very fact that I'm sending you before the vacation bench, it means it is for interim prayer. Yes.
Request is for accommodation.
Already, you don't want this order to be recalled?
Please, give counsel some difficulty today.
ಅದರಲ್ಲಿ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದ್ರ ಮೇಲೆ ಇದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ. There is no representation for the petition. This is for non-prosecution.
Please, some difficulty during the 2020 COVID period.
Yeah.
That there was the petitioner taken NOC from the previous council. During the span of 1.5 years, there were some difficulties due to the pandemic, which there could not be any representation. She could not engage. They could not engage the other council.
At the request of learned counsel for petitioner, release this matter immediately after summer vacation 2020.
Okay. Before I take for the petition, the matter pertains to the counting of the service rendered before the period of regularization.
Early hearing. Is this matter immediately after summer vacation 2022. IA number 1 of 2022 is accordingly disposed of. Date ಕೊಡಕ್ಕೆ ಬರಲ್ಲ.
Due to the odd ailment of the respondent counsel, my lord is unable to appear today's articulate, my lord. He requested for short adjournment.
Yes, list this matter after summer vacation. Matter is called out. There is no representation for the petitioner. List this matter after summer vacation. Interim prayer ivaga 2019 matter.
Location. And the only simple point is involved in this matter. The fact being that
Shanmukha Matter is called out. There is no representation for the respondent. Dismiss matter after summer vacation. Date ಕೊಡಕ್ ಬರಲ್ಲ.
This matter, I appear for the respondent. This has to be heard.
The case of dismissal. Ground that the
Has to be heard.
They heard not without any employment for the last 3 years because he is only.
ಸರಿ, ಇವಾಗ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಇವತ್ತು ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಹೇಳಿ ಸರ್? You have filed objections?
Yes, my lord, I have filed objections.
Is this matter immediately after summer vacation?
Paper direction to continue to work and pay the salary merit because what happened, my lord, respondent number 3 and 4 without any speaking order, without any government order, they are not allowing to me work as a bill collector, my lord. Because served more than 20 years, my lord. Only attendance ನಲ್ಲಿ ಎಂಡಾಸ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಸರ್ಕಾರದ ಆದೇಶ ಪ್ರಕಾರ ನಿಮ್ಮ ಅಟೆಂಡೆನ್ಸ್ ಪರಿಗಣನೆ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಯಾವ ಆದೇಶ ನಂಬರು ಹೇಳಲ್ಲ, ಯಾವುದು ಹೇಳಲ್ಲ, ಇಂಪೂನ್ ಆರ್ಡರ್ನು ಹೇಳಲ್ಲ.
Your interim prayer has been rejected. ಅದನ್ನ ಹೇಳಬೇಕು ಸರ್. What are you submitting then? There is a specific order. Therefore, in terms of the affidavit, there can be no question of granting any interim prayer, directing marking of attendance to the petitioner. Is this matter after summer vacation?
Identical matter honorable court has directed, my lord.
Identical ಬರೋದಿಲ್ಲ sir. In your case, there is a specific order. Yes. ಬರೋದಿಲ್ಲ. No sir.
ಏನಾಗಿದೆ ಅಂದ್ರೆ NOC
ದಯವಿಟ್ಟು. No sir. No, I am not. No, no, no. No date. No date. No sir. No sir.
Otherwise, I will withdraw the petition.
ಹಾಕಿ ಮೆಮೊ ಹಾಕಿ. ಮೆಮೊ ಹಾಕಿ.
Liberated to press.
ಕೊಡ್ರಿ ಪೇಪರ್ ಕೊಡ್ರಿ ಅವ್ರು. Learned counsel for the petitioner.
Please, my lord. I am taking instructions after immediately after.
Yes. Yes.
Previous occasion, my lord, sir. Carry the matter, my lord. Petition. Carry the matter, my lord.
Yes, you said.
My lord, sir, I filed a memo dated 7/6/2021. Delhi High Court order. Number 5.
Additional?
I have filed an application to receive my additional statement of objection. That is all clear. Place the judgment.
That was already there. You are referring to that Delhi High Court judgment.
Yes.
It was already placed on record.
Yes. Page number 100. Learned single judge had pointed out the maintainability issues. After contention from both the parties, the judge has pointed out in the paragraph 67, the Supreme Court has time and again held that once the state or its instrumentality
is a party to a contract, it has an obligation in law to act fairly, justly, and reasonably, which is the requirement of Article 14 of the Constitution. The Supreme Court also observed the scope of judicial review in contractual obligations may be limited and parties may be relegated to adjudication of their rights by resorting to remedies for purely contractual disputes. However, to the extent the challenge to an impugned act is on the ground of arbitrariness and unfairness to the touchstone of Article 14. The fact that the dispute also falls in the domain of contractual obligation would not relieve the state of its obligation that to this extent the obligation is of the public character.
No. What was the dispute there? And what is the dispute here?
Yes, I'll just point out the issues framed by the judge. Page number 53.
Same dispute regarding termination, my lord.
1 second. I'll come to that. Page number 53. The issues framed by the judge is in the D, paragraph D, whether the petitioner whose terms and conditions of the service were governed by fixed term contract can enforce their contract of employment, seeking extension renewal of FTC by invoking the writ jurisdiction of this court under 226.
Terms and conditions of service.
Yes, ma'am.
Can enforce their contracts of employment or seek extension, renewal of the
FTC by invoking the writ jurisdiction of this court.
FTC means
a fixed term contract. Article 226 of the Constitution. So there, the learned single judge in the page number 100.
And what is the dispute brought before this court?
A dispute with regard to the termination. And paragraph 68, page number 100. In Godavari Sugar Mills versus State of Maharashtra, the Supreme Court held that where the list has a public law character or involves question arising out of public law functions on the part of the state or its authority, access to justice by way of public law remedy under Article 226 of the Constitution will not be denied. In Rajasthan State Industrial Development versus Investment Corporation and another versus Diamond and Gem Development Corporation Limited and another, Supreme Court held as follows. It is evident from the above that generally the court should not exercise its writ jurisdiction to enforce the contractual obligation. The primary purpose of the writ of mandamus is to protect and establish rights and to impose a corresponding imperative duty existing in law. It is designed to promote justice. The grant or refusal of writ is at the discretion of the court. The writ cannot be granted unless it is established that there is an existing legal right of the applicant or any existing duty of the respondent. Thus, the writ does not lie to create or to establish a legal right, but to enforce one that is already established. While dealing with the writ petition, the court must exercise discretion, taking into consideration a wide variety of circumstances.
What happened ultimately in this matter?
Well, I'll just point out one.
Ultimately, all the employees were
page number
reinstated.
Reinstated. Page number 105. Tested on anvil of aforementioned principle of examining the action of the state or its agency, this court is compelled to conclude that the impugned action is violative of well-settled legal position and suffers from arbitrariness and unfairness and fails on the touchstone of Article 14 of the Constitution. In this view, the writ petitions are maintainable and the argument of the respondent to the contrary cannot be contested. And one more thing, my lords.
What is the difference between
Here,
those
when
matters
this judgment was passed, it was an instrumentality of the state because at that point of time, privatization was not complete. This judgment was rendered on 1/6/2021, my lords. Subsequently,
no, even as per the agreement?
Yes, my lords.
At the time of what you say, the transfer of shares.
Please, my lords.
They have pointed out that all the employees.
Yes. As on date of that particular date shall stand. But on that particular day, the petitioner was not in service, my lords.
But that very same issue has been considered here.
No, my lords.
Then
that decision, this is pertaining to during the COVID time, number of employees, number of pilots were terminated. That was challenged in this writ petition, and during the during the period when the company was stayed within the definition of Article 12, this particular judgment was passed, my lords. Subsequently, when privatization happened, the issue will not lie before this honorable court in view of Article 12, my lords. In similar circumstance, in Palco's case, also the same thing happened, my lords. During that, also the issue of termination was raised before the Delhi High Court, and Delhi High Court Division Bench of Delhi High Court said once privatization happens, the writ jurisdiction will not lie. I'll place that Palco's judgment as
My lords, I have one more submissions to page number 33. The submissions made before the single judge. It's in the page 33. There, the same termination order which has been a reference number is common to all the people, even this petitioner. Page number 33.
Which means orders have been passed by one court of this country in respect of the same termination order.
Same.
no, petitioner is not part of.
Not necessary, sir.
No, it is not a common order, my lords.
No, that is what he is pointing out.
One second, I'll submit. It is not a common order.
Page 33, first paragraph. This is the petitioner contention. My lords, last 3 paragraphs. In the above paragraph. This is amply demonstrated that not only by the plain reading of the aforementioned orders, which are identically worded, but also the fact that they bear the same reference number HPTO 1/02701. My lords may see the annexure claims, annexure. We have challenged the same thing.
It is there in your prayer.
Yes, my lords. And the annexure Q.
Set aside the impugned letter bearing number HPDOI bar 0-2701 dated 13/8/2020.
Annexure Q, page 94. The same. It is common to all the petitions.
Yes, sir.
Maybe tomorrow, day after, my lords, I'll seek instructions and submit, my lords, on this particular aspect, my lords.
Now, what has happened to that judgment of the Delhi High Court?
That
reinstated all
reinstatement
the
order.
Employees.
How can you contest this matter, sir? If it is with reference to the same.
Yes, my lords. Maybe tomorrow, my lords, I'll seek instructions and submit, my lords. It is with respect to this particular petitioner is not part of that.
Not necessary, sir. Sir, if it is a establishment of the government of India earlier.
Yes, my lords.
Pertaining to the entire country. There was only one Air India.
Please, my lords.
And its employees were spread over the entire country.
Yes.
And if an order has been passed by Air India, on 13/8/2020 with reference to a particular common order, and the same is made applicable to the petitioners here, and the same has fallen for consideration before another high court, and orders have been already passed, and that has been implemented. How can you deny that one only because the company has subsequently been has become a private company?
Yes, I'll seek instructions on that and we'll post it tomorrow, my lord.
In terms of the directions given on 13/4/2022, learned counsel for the petitioner seeks to substantiate his contention that the question of maintainability of the writ petition has already been considered in the case of Arjun Ahluwalia versus Air India Limited, by the High Court of Delhi, learned counsel has taken this court through some of the paragraphs of the said judgment. More particularly, it is now brought to the notice of this court that the order in reference bearing number HPTO 1/0-2701, which is impugned in this petition, was the very same order in reference in the order of termination passed against the petitioners before the Delhi High Court. So, learned counsel submits that the Delhi High Court held that the writ petition was maintainable and proceeded to allow the writ petitions while directing the respondent to reinstate the petitioners while setting aside the orders of termination. Stop. Learned counsel therefore submits that since a common order of reference, which was the basis of the orders of termination, including the termination order impugned before this court, had fallen for consideration, and the respondents have implemented the directions given by the Delhi High Court, similar benefit is required to be given to the petitioner here. Full stop. Next para. Learned counsel for the respondents seeks for a short accommodation to seek instructions and make submission. Full stop. Release this matter tomorrow.
Not so much.
Amendment of the
respondent 1 and 2, no objection for both the applications.
Amendment and amendment.
Who are these?
Not, they are not the persons who not would be affected, the impeding persons.
What is the matter about?
Pertains to not the appointment of assistant engineers on contract basis. They have to be regularized. But they were recruited not on contract basis because at that time government said we don't have money. Therefore, you recruit them on contract basis. It was not for vacant posts and not by notification.
And who are these proposed respondents?
They are not the persons who have also been subsequently.
They are, as per the seniority list, they have been placed much before the
They have
petition.
been placed above us. We have to be, my lord, seniors because we were recruited prior to them.
And what is this amendment?
Amendment, my lord, is small seniority list challenge ಮಾಡಿದೆ. Seniority list, my lord, where, my lord, they have been shown as
during the pendency of the writ petition, first respondent has issued final seniority list.
That is big.
Okay. Order on IA number 2 of 2021. This application is filed for including the proposed respondents. Since the proposed respondents who are also working as assistant engineers, electrical, have been placed above the petitioners in the seniority list, and any order that could be passed by this court would affect the proposed respondents. Full stop. The counsel for the respondents. Respondents ಅಂದ್ರೆ ನೀವು what about
ಅವರಿಗೆಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿದೆ, they are served but not come.
Though notice is served on the proposed respondents, there is no representation. Stop. Nevertheless, learned counsel for response number 1 and 2 submits that there can be no objection for allowing the application. Full stop. Consequently, IA number 2 of 2021 is allowed. The proposed respondents are permitted to be brought on record as respondents number 3 to 10. Learned counsel, next, IA number 3 of 2021. This application is filed to amend the writ petition. So, it stated that during the pendency of the writ petition, the first respondent has issued the final seniority list of assistant engineers, bracketally electrical, bracketally graduates, and therefore the said final seniority list is also sought to be challenged, and therefore grounds are made out to raise a challenge to the final seniority list, and a prayer is also sought to be added in this regard. Full stop. Next para. The counsel for the respondents has no objection to allow the application, but the learned counsel submits that the respondents may be permitted to file additional statement of objection. Full stop. Next para. Consequently, IA number 3 of 2021 is allowed. Learned counsel for the petitioner is directed to carry out the amendment in terms of the application in IA number 3 of 2021 and the amendment in the cost item as per IA number 2 of 2021. So, the same shall be carried out within a period of 1 week from here. And furnish amended.
Your Lordship, they only contesting third and fourth respondent.
Respondent 3 and 4.
Have
One week time I file objection.
Idರಲ್ಲಿ, your Lordship may kindly see their only objection is based on Delhi High Court judgment. The Delhi High Court judgment is pertaining to year 2013 onwards, which is not applicable. Yeah, but this petitioner has completed the degree in 2011, so that judgment will not be applicable as per that.
Yeah, what do you want now?
This application I said for disposal.
Disposal. For posting ಇದೆ. For disposal.
Disposal ಗೆ ಕೇಳಿದೆ, ಯಾಕಂದ್ರೆ the only objection is by the third and fourth respondent is they have cited the Delhi High Court judgment saying that the Delhi High Court has state the recognition of the degree obtained by the petitioner, but the Delhi High Court has stated the recognition of degree obtained by the
petitioner only from the year 2013 onwards. But this petitioner has completed the degree on 2011. I have produced the document. So that objection cannot be sustained in this case. And the Umadevi's case, and this from 2008, this petitioner is working in the same institution on a meager salary.
ಏನಾಯ್ತು ಆಮೇಲೆ ಪ್ರಾಬ್ಲಮ್ ಏನಾಯ್ತು?
ಏನು ಇಲ್ಲ, ಇಲ್ಲಿವರೆಗೂ ರೆಕಗ್ನೈಸೇಷನ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇ. They are not regularized their pay job, though she is entitled only on the ground that the degree obtained by the petitioner is not applicable, and the Delhi High Court has stayed on that. But the Delhi High Court has stayed only for the batch 2013 onwards, not for 2011.
Delhi High Court. You have obtained degree from where?
From annexure. Your Lordship may kindly turn to annexure, page 25, annexure C. This is a post-graduation degree certificate. I have obtained on 3/1/2011. Your Lordship may kindly turn to next page, annexure D. There is a clarification also issued by the second respondent. Only those who had obtained after 31 May 2013, the Delhi High Court has stayed only for them. It is not recognized.
What was the problem?
There was no problem at all, but
why was it not recognized from May 2013, sir? What is the problem?
That is the issue is pending before Delhi High Court, the case.
Please read this public notice. Please read the public notice.
Whereas MHRD of Government of India, through an order by OM number 11/15/2000, withdraw the recognition granted to all certificate qualification awarded by the professional bodies in institution in the field of technical education. MHRD further stipulated that from 1/6/2013 onwards, the courses for equivalence will cease to have effect for employment in central government, and decision of continuation of certification of degree diploma would be taken by statutory regulatory AICT after review. This is only after 2013. My thing was on 2011. I completed. So this and
distance learning
only they have to do the post graduation anywhere in when AICT took control for the entire country. They said that for teaching in engineering college, post graduation is required. So everyone who were working, they started to take post graduation degree and all examination, and they passed. Like similarly placed petitioners in the same institutions have also passed the PG, and they got their job regularized. But only this petitioner, though she is working from 2008 till today, her thing is not been recognized. When an explanation was sought, they gave this notification saying that the Delhi High Court has said we are awaiting for the Delhi High Court judgment. But even if the Delhi High Court judgment comes, it is only for the batch 2013 onwards, not for 2011.
File statement of objection. File statement of objection.
Or last time stay ಹೇಳಿತ್ತು Delhi High Court stay ಇದೆ ಅದಕ್ಕೆ
objection instruction.
And let there be at least they should not relieve me from
submitting that for other teachers you have regularized. Why you are singling out the petitioner?
Kind after vacation to file statement of objection.
And let there be at least they should not put me in relieve me out of some job or something. If they want to take objection, let them not relieve, because the time is there. They may try to find some reason and they may
learned counsel for the petitioner submits that even if the contention of the respondent institution is accepted, that the Delhi High Court,
in page 3 of my application, I have quoted the number. Para 5, WPC 4059 of 2019, W.P.C. They use the word C, W. Registration.
WP bracket C 4059
of 2019
and CM appeal number 1837 of 2019.
A copy also not served, my lord.
Held that the post-graduation certificates issued by DOEAC bar NIE-LIT Society, New Delhi, after 2013 is not valid, however, since the petitioner obtained the certificate in the year 2011, the case of the petitioner for regularization is required to be considered. Full stop. It is also submitted that the case of the other teachers.
They have done in other colleges in the PG course, because at that time, after Uma Devi's case, there was the two issues came. One is
who completed their post-graduation in other institutions have been regularized in the respondent institution. Full stop. Nevertheless, learned counsel for the respondents seeks for some time to file statement of objections. Full stop. Next para. While permitting the respondents to file statement of objections, it is made clear that during the pendency of this petition, the services of the petitioner shall not be terminated. Okay. What, madam?
Huh? Yeah, I have to comply the office objection. I will permit him to comply the office.
Based on objections. Huh?
I'll comply to called upon.
What are the objections?
Affidavit swear I will not tell you. According to me, I think filed
each time is granted at the request of the learned counsel for the respondent to comply with the office objections raised on the objections filed at the hands of the respondent. Then interim order has to be extended.
That is right. The matter has to be argued. It's regarding the transfer.
Interim order granted earlier stands extended to the next date of the.
Lords could recall, Lords, this matter pertains to implementation of K. Narayan's judgment and P. Sudhakar Rao, along with the board orders of the KPTC. The seniority between the direct recruits and the ABT engineers. Now, I am ready with the matter, subject to my Lord's.
Take it up after vacation. With this matter, after summer vacation 2022. Interim orders.
Some urgency.
Immediately after summer vacation. Interim order granted earlier stands extended to next year. Matters called out. There is no representation for the petitioner. Is this matter after summer vacation? Gautam Dev Ullali. Manjula T. What about Gautam Dev Ullal ಅವರು ಇಲ್ಲ
ಅವರಿದ್ದಾರೆ
ಹೆಂಗಮ್ಮ 2 and 3 ಅಂತಿದೆ ಅವ್ರದ್ದು 2 and 3 ನೀವು ತಾನೆ ಹೌದು ಹಂಗಂದ್ರೆ ಗೌತಮ್ ದೇವ್ ಉಳ್ಳಾಳ್ ಅವರಿಲ್ಲ ಸರ್ ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು remove the names of Leonard councils Srimati A.D. Vichya, Shri Basareddy, Mallikarjun C. Basareddy and Shri Gautam Dev C. Ullal. Since Leonard Council, Srimati Manjula D. is appearing for response number 2 and 3. Yes. Matter is called out. There is no representation for either of the parties. For petitioner. Is this matter after summer vacation?
Petitioner's counsel. The petitioner was wrongly denied appointment, not though she is meritorious in her scorecard. So it's a wrong calculation. Lord, I have filed early application. 2012 let me tell you, she has been denied appointment, though she is deserving. Have we a date?
At the request of the Learned Council for the respondent, release this matter immediately after summer vacation. Date ಕೊಡಕ್ ತಪ್ಪಾಗುತ್ತೆ.
ನಾವೇ ಒಂದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ವಿ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್.
ಆಯ್ತು, ಡೇಟ್ ಕೊಡೋದು ತಪ್ಪಾಗುತ್ತೆ. ನನ್ ಮುಂದೆ ಬರೋದಾದ್ರೆ ನಾನು ಡೇಟ್ ಕೊಡಬಹುದು, ಬೇರೆಯವ್ರ ಮುಂದೆ ನಾನು ಡೇಟ್ ಮಾಡಿ ಫಿಕ್ಸ್ ಮಾಡೋದು ತಪ್ಪಾಗುತ್ತೆ. That is called out. There is no representation for either of the parties. Is this matter after summer vacation?
In this matter, the petitioners originally were seeking for a regularization and absorption. And during the pendency of the writ petition, the government took a policy decision to redeploy the petitioners. Majority of the petitioners are redeployed, and only few petitioners are remaining and who are not willing to work in a redeployed case. Matter needs to be heard. Logic has directed for the final hearing. That is the reason.
Same order. Matter is called out. There is no representation for the petitioners. List this matter immediately after summer vacation. Same order. For representation for the petitioner. For representation for both the sides.
Is not petitioner dismissed from service.
Appear for the respondent, my lord. Serial number 42, my lords.
Application may not matter. Dismissal matter may not.
List this matter after summer vacation.
Much obliged.
No representation for either of the parties. Same order.
35 and 39 ಒಳಗೆ waiting, I could not able to hear. I was very much present, but not able to notify that. I could not able to hear which matter was called.
I have listed after vacations.
Anyhow, my
After
absence is recorded, my lord. May kindly be. 35 and 39 both.
35 and 39 ನಲ್ಲಿ simply say list this matter after some.
Very
yes. Yes. Representation for the petitioner.
Respondents 4 to 6
Lord, 46, I appear for the respondent.
No representation for the petitioner. Is this matter after summer vacation?
The connected matter I am for the petitioner.
For the petitioner sin
9380.
WP number 50265 and 4453. Yes.
Lords, 44 I have there that my present 44 your lordship may I could not then
all right.
Please my lords, much obliged.
44 your Prakash simply list this matter after summer vacation.
Much obliged, my lord.
After vacation.
No representation for the petitioner. Yes. Representation for both the sides.
On behalf of respondent number 3, Your Lord.
No representation for the petitioner. Is this matter after summer vacation? Representation for both the sides. Same order.
For the petitioner, my lord.
No representation for the respondent.
They have filed an objection. Respondent have filed objection.
If they were there, if they had said, I to consider, we could have done. They are not here.
Filed objection and earlier date also
they are contesting the matter.
Okay.
We have to. Yeah.
My lord, matter number.
Serial
List number
number
47,
52.
my lord. I am
Adjourned,
from
adjourned.
petition, my lord, list number 40.
Adjourned.
My lord, my
adjourned.
present may be recorded.
Sorry.
Okay.
Motion is
Thank you, my lord.
Aitappa. No representation for the respondent. Is this matter after summer vacation? 52.
Tomorrow I can take it. Petitioner. The government advocate go through the similar order. Lordship has passed. Similar order.
ಜಡ್ಜಿಗೆ ನೋಡ
Similar orders. So same orders as in WP number 1697. 2022. Next year. Therefore, the respondents are directed to consider the representation dated 1/1/2021 at annexure.
Annexure R.
Annexure R.
Representation dated 3/8/2016.
Representation dated
3/8/2016.
And
same
at annexure R.
R and R.
and R1. Yes. ಇದೆಲ್ಲ same.
For petitioner, this interim order kindly be extended, madam.
Memo for disposal, who has filed?
I do not. I have not been served a copy with notes. I do not know who has filed that notes.
Matter is called out. There is no representation for the respondent. Is this matter after summer vacation? Interim order granted earlier stands extended till the next date of year.
Grateful.
Employment till the end of the academic.
ನೆನ್ನೆ ಬಂದಿತ್ತು.
Page 57. And this is language.
ಬನ್ರಿ ನೀವೇ ಸಂತೋಷ್ ನಾಗರಾಳೆ ನಿಂದೆ ತಾನೆ?
Please go. This is Bangalore University. Bangalore University.
Mr. Ramesh, Mr. B. Ramesh.
You have made as respondent number 3. Representative number 3.
What has happened to that other matter which is now before the division bench? Ali, is there any relief given to the petitioners?
Bharat Sai Kumar.
Howdo.
The person died 1 month back.
No. If any relief is granted to the petitioners, directing them to be continued in service, the same benefit can be given to you. Otherwise,
Wherever there is an interim order,
since
there are some other.
so you will have to point out that this is the type of interim order granted and that benefit is availed by the petitioners. You will have to point out. Otherwise, if a direction is given now, it will be in contravention of the.
No, Lord. This is not continuation beyond superannuation. Page 57, you lost my kindly see. This is nothing to do with the superannuation. Page 57,
File
Bangalore University statute said, if a retired age of superannuation ballot occurs in the middle of the academic, a statute is said you will be entitled to. Now I made an inquiry. The November ballot is a 2021 is the academic year, and he retired ballot is December 31. And he put an application on 30th. Page 57. Subject to the terms of any contract, a person appointed as a permanent teacher of the university shall be entitled to be in the service of the university until he or she complete the age of 62 years. If the age of superannuation is attained in the middle of the
complete the age of 60 years.
Yes, 60 years. If the age of the superannuation is attained in the middle of the academic year, the teacher shall continue till the end of that academic on re-employment. Lord, I am only asking that I may continue till the end of the academic. That's it. On re-employment. On 30th, I gave a letter. 31st for the. Now my letter says that there is some result, there is no such allegation. Audit report ಅಲ್ಲಿ ಏನೋ ಕೆಲವು accounts missing ಅಂತಿದಾರಂತೆ. That is in the department, not so far as me is concerned. I made an inquiry.
So you have made the application.
30th.
Have they passed any order?
No, there is no order. Therefore, my lord, but I made a request to lordships on the other day. Let them pass an order on that application. This is forwarded.
ಮುಗಿದೇ ಹೋಯ್ತಲ್ಲ ಇವಾಗ. We are in the end of April. Academic year
ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಎಂಟೆಡ್ ಆಗಿದೆ.
ಹೌದು.
ಈಗ ನವೆಂಬರ್ ವರೆಗೂ ಇದೆ.
ನವೆಂಬರ್ ವರೆಗೂ ಹೆಂಗಿರುತ್ತೆ? ಅಕಾಡೆಮಿಕ್ ಇಯರ್ will end in
university academic year commences. We made an inquiry.
I'm waiting for respondent number 3, my lord. He is employed. Petitioner is employed in Bangalore University.
Bangalore University.
Bangalore University.
ಹೌದಪ್ಪ.
I'm waiting for respondent number 3 meeting.
VTU, correct. They are asking you, when does the academic year end?
Normally it depends on June, July. It starts from August and it ends in.
No, my lord. In fact, the petitioner was here, my lord. He has just gone outside. He had a document. Till November.
Please come at 2:30. ಅವರು ಅಷ್ಟೊತ್ತಿಗೆ ರಮೇಶ್ ಅವ್ರಿಗೆ ಬರಕ್ಕೆ ಹೇಳಿ.
I have a special pen. My colleague would be here. He will produce the academic year.
ಆಯ್ತು. ಏನಕ್ಕಪ್ಪ? ಆಯ್ತು, ಪಾಸ್ ಹೋಗು. ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಗಳಿಗೆ ಬೇರೆ
party more my lord last because my lord has directed the Mysore Medical University advocate my Gole, Mr. Gole, to produce the original record, secure the original record. Even today they have not produced the original record. I have also my lord, there is a
come up after vacation.
Three direction my lord for that. My lord. Date my lord. Date.
ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲಪ್ಪ, ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀರ?
ಅಲ್ಲ ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅಲ್ಲ ಅವರು ಏನ್
ಮಾಡಿಬಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅದೇನ್ ಮಾಡಿದ್ದಾರೆ,
ಐ ಕಾಂಟ್ ಗಿವ್ ಡೇಟ್ ಲೈಕ್ ದಟ್.
ಡೆಸ್ಟ್ರಾಯ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದಲ್ಲ ಸ್ವಾಮಿ, ಪ್ರಾಬ್ಲಮ್ ಇರೋದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ರೋಸ್ಟರ್ ಚೇಂಜಸ್. ಹೌ ಕ್ಯಾನ್ ಐ ಗಿವ್ ಎ ಡೇಟ್? ತಪ್ಪಾಗುತ್ತೆ, ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಐ ಹ್ಯಾವ್ ಸೆಡ್ ಆಫ್ಟರ್, ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇಟ್ ವಿಲ್ ಕಮ್. ಎಸ್. ಏನು ಹೌದ್ರಿ, ಕರೆದ್ರಿ ಇಲ್ವಲ್ಲ, ಮತ್ತೆ ಕರೀರಿ ಆಮೇಲೆ 2:30. ಮಾಡಿದ್ರ
ಅಷ್ಟೇನು ಪಾಸ್ ಅವ್ರಾಗಿ
ಮೇಡಮ್ ಟೋಟಲ್ easy. Canada included teachers. But if you have close together, one increment ಕೊಡ್ತಾರೆ. ಬಹಳ ಜನ ಮಾಡಿದ್ದಾರೆ. ಓನ್ಲಿ ಟೀಚರ್ಸ್ ಸಿಗಿದೆ. ಇಲ್ಲ ಅದು ಟೀಚರ್ಸ್ ಇರೋದು, ಅದು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಈಗ ಬೈಲ್ ತೆಗಿಯಕ್ಕಾಗಿಲ್ಲ. ಸರ್ 21
ಎರಡೂವರೆಗ ಬರ್ತೀವಿ.
ನಿನ್ನೆದು ರಿಸರ್ವ್ ಅದು ಬೆಳ್ಳದ ಸರ್, ಒಂದು ಬೆಳ್ಳದ ಕೊಟ್ಟಿದ್ದಾರೆ ನನಗೆ. ಆಮೇಲೆ
43 ಮತ್ತೆ 54 ಅಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ತಗೊಂಡಿದ್ರಲ್ಲ ಅದನ್ನ ಊಟ ಅಲ್ಲಿ ಒಂದು ನಂಬಿ ಅಂತ
ನಿನ್ನೇನು ಹಂಗೆ ಇಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಅದು
Good officer.
ಇವತ್ತು ನಾನು ಮೆನ್ಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Good officer. Good officer. Sir, कैसे है sir? Good officer. ಹೌದು ಸರ್ 7705. ಕೋಡ್ ಆಫೀಸರ್ ಮಾತಾಡ್ತೀವಿ. ಕೋಡ್ ಆಫೀಸರ್
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಹೆಂಗೋದೆ ಸರ್?
ಸರ್ 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 ಕೋರ್ಟ್ ಮೈಕ್ ಮ್ಯೂಟ್ ಆಗಿದೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 54 ಏನಾಯ್ತು ಸರ್?
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತೆ ಸರ್.
51 ಸರ್ 51 ಸಾರಿ. ಕರೆದ್ರ ಅದು ರೀಚ್ ಆಯ್ತು. ಅದು
ಕರೆದ್ರಂತೆ ರೀಚ್ ಆಯ್ತಂತೆ ಸರ್. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೇಳಿದ್ರು.
Sir, court officer, sir. Court officer. 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 No, sir. Ground, sir.
Again, sir.
Hello, court officer.
Sir.
One case urgent ಯಾವಾಗ ಆಗಿದೆ ನೋಡಿ.
Serial number ಎಷ್ಟು sir?
Serial number 34. 34.
After vacation.
Okay, thank you, sir. Thank you.
Serial number 57. 40%.
For the second response.
From many angles, this is not a case warranting interference at the hands of this court. Consequently, the petition stands dismissed. Having regard to the above, this court is of the considered opinion that the decision of the BRCS in setting aside the order of disqualification passed against response number 1 and 2 does not call for interference. Consequently, the writ petition stands dismissed.
Morning session, the past hour matter. This was taken up at 2:30. So not in the morning session. But the question was asked to my colleague Millard.
Who is the appointing authority?
Yes. Producing this document. Then Millard has been promoted to the executive engineer. My name Millard is at serial number 32. This is the promotion order, Millard. It was given by the BBMP authorities. My name Millard is at serial number 32.
Adalla. Who is the appointing authority for executive engineer is the question.
Yes, in this case, Millard, it is the BBMP commissioner Millard was signed the order. What a question.
Is the order of promotion.
Yes.
But even in terms of the
I was promoted to the executive.
promoted, sorry, who is the appointing authority for executive engineer is the question.
As per the old regulation, to my best knowledge,
Therefore,
yes.
If the appointing authority is the state government, then that decision will not be applicable. That is the.
I'll clarify to that extent. Now, guidance in the Karnataka Local Act, it defines government servant and a public servant. Government servant are the civil servants.
See, now if you want to get the benefit of that order passed by the division bench, I've gone to that and I've given I have passed many orders. Now the only question that that needs to be clarified here is who is the appointing authority for executive engineer of the BBMP?
Even assuming but not admitting,
if it is the state government, then you will not get the benefit.
I'll clarify to that extent.
Yes.
Yes. Assuming not admitting the fact that assuming that the government is appointing authority so far as executive engineer concerned. Now, this article, section 14A is very clear. For a moment, 14A of the KCSCCA will be kindly be taken. It says that 14A will apply only insofar as government servant is concerned. Here, my lord, even if the appointment is made by the government, since I am under the BBMP, I do not become a government servant. I become a public servant. That is why, my lord, the definition of the government servant and public servant may kindly be.
It cannot be read so simply. There are cases where the a government servant who is appointed by the state government or any other authority under the state government, a competent authority, they may go on deputation to other corporations, municipalities, so many places they go. They cannot claim that they are employees of the corporation. That is why. No. That is why that word cannot be read so simply. Therefore, That is why I asked for a clarification. Who is the appointing authority for an executive engineer?
I'll have to just verify because we're not now for a moment the division bench order of the bench head by Justice Nagartha may kindly be seen. Where it is page paragraph 37. 37 page 90 may kindly be seen. Based on which not the interim orders have been granted by this honorable court.
Yes.
Paragraph 37 page 90. Zero. What emerges from the outset discussion is that Karnataka Lokayukta Act defines both public servant as well as government servant. The competent authority under the said act for public servant as defined in section 212G is the state government. Further, under CCA rules, the expression government servant is defined in the expression disciplinary authority in relation to the imposition of a penalty on a government servant is the authority competent under the rules to impose on him that penalty. But the said rules do not apply to public servants as defined under section 212G of the Karnataka Lokayukta Act, inasmuch as Rule 31D excludes the application to them. Rule 14A of the CCA rules deals with entrustment of the inquiry to Lokayukta only with respect to government servants and not public servants. In the absence of there being such a provision for entrustment of inquiry to Lokayukta against the public servants under the CCA rules, the government servant cannot enter such an inquiry to Lokayukta or Upalokayukta as the case may be under the said rules. Further, the state government is also not the disciplinary authority in respect of such public servants. Therefore, the state government, on receipt of the report from Lokayukta or Upalokayukta, must submit the same to the disciplinary authority under the particular C&R regulations on the entity in which the public servant is employed. Now, let's for a moment kindly see the definition of the public servant and the government servant under the Karnataka Lokayukta Act.
Is there any petitioner who is of the cadre of executive engineer?
In this case, my lord, he was a retired executive engineer.
Retired executive engineer.
Yes, yes.
All right. Same order as in?
Lord, as in I have produced the interim order by your lordships, which is at page 87. Anish Saren.
Similar order. Page number 87, 88. ಅದೇ ತರ ನೋಡ್ ಹಾಕ್ತಾರೆ. Why is this Ramesh not coming? Huh? ಅವರು ಇಲ್ಲ.
Third semester would come to an end on 10/5.
10/5.
Fourth semester, November 2000. I'll give this to my lieutenant Ramesh. but only 2 professors are there. And as per the AICT norms, MBA, 60 students with 4 semesters, 14 teachers are. This is the 3rd semester.
ಮುಗಿತಲ್ಲ ಸರ್, ಮಾರ್ಚ್ಗೆನೆ ಇದೆ, even according to this.
No, 4th semester.
No. Huh?
4th semester, 2 years. Course. It is MBA 2 years.
What is?
Same. There up to November 2020. Now let our application be considered within a week, so that it is for the university to re-employ me in view of the statute, page 57. Page 57, you will also get 21.2 statutes. I have extracted grounds for interview. Page 33 of the petition.
Correct. Since it is the contention of the petitioner that in terms of the requirement of clause 21.2 of the statutes of the Bangalore University, the petitioner who attained the age of superannuation as on
31/12/2021, and on 30th application for
31/12/2021.
That's the application forward. Or continued still
Filed an application on 30th of December 2021. Seeking extension of services till the end of the academic year 2021-22. The respondent university was required to pass orders. Stop. Therefore, since no orders are said to have been passed on the application filed by the petitioner, the respondent, Bangalore University, is hereby directed to pass orders considering the application of the petitioner, having regard to the provisions contained in clause 21.2 of the statutes. On or before 27th of April 2022. Stop. List this matter before the vacation bench on 28th of April 2022.
Sorry, Lord, I was held up in the other court, Lord.
maybe pardon.
ಹೇಳಿ.
But the petitioner was appointed as a junior engineer in the Niravari Irrigation Department. On the backlog vacancy, according to Supreme Court orders, it was appointed by Annexure A. Hardship can have a glance. They read that particular para itself.
You know what is this?
Not Panchayat.
What is this?
But this is an appointment order which was backlog vacancy put in the apartment order.
Sorry.
I was told to report to the concerned department on the Annexure B, Lord, Your Lordship, I have a glance at it. 25 January 2017, I reported. My services, Lord, was to be counted from 2003 onwards, Lord. I was in service. ನನಗೆ appointment permanent ಅಂತ ಆಗಿದ್ದು 2017 ನಲ್ಲಿ. The date of birth of mine, Lord, was wrongly entered as from 60 to 1962, whereas my date of birth is 1963. Your Lordship kindly have a glance at Annexure C.
ಇವಾಗ ಏನು ಅದನ್ನ
ಏನಾಗುತ್ತೆ? Civil court has declared that date of birth because there was a notice which was issued by the issued to the department that my date of birth is changed. So this difference it is changed according to my date of birth is not there. But there was no reply from the department. So again, I filed a OS before the court below Mysore. Court has decreed it. I have submitted all those documents together with that to the department. Till date, no action has been taken. And Lord, Your Lordship kindly have a glance at Annexure G. All the documents which from SSLC marks card up to the other marks card, everything is changed according to the degree of the court. Now, Lord, I would be left out with 1 year of service in case if it is changed to 1963 in place of 1962. Lord, my last date of service would be 30th April, Lord, in case if it is 63 is considered. If 62 is considered, Lord, I will be serving for 1 more year because my appointment is only from 2017 onwards. Otherwise, I was a contractual basis employee in the department. But all these things, Lord, for 1 year of service, Lord, all these things I have done. And moreover, I could have moved this honorable court before, Lord, because of the pandemic, Lord, I could not move for 7-8 months. And I have made representation to each and every department, and I have personally met people, but they have not inclined to grant any relief till date. And as per Your Lordship direction, the last occasion, Justice Bimay Avargunu copy ಕೊಟ್ಟಿದ್ದೆ, and I requested him.
I received the copy, man. I received the copy.
ಹೇಳಿ, what is your subject?
My lord, is seeking for the writ of mandamus directing the respondent to relieve not to relieve the petitioner, my lord, based on the city civil court decree, my lord. So it is ultimately it is for the. And with regard to the interim order is concerned, I leave to Your Lordship because since there is a decree, and one submission is that, my lord, at least the petitioner could have made this department also party for the civil court, but in civil court this respondent has not been made party, my lord.
When did you give the application seeking correction in the correction of the date of birth in the service register?
First application which I made was in 16/11/2017.
Where is that?
That not this of late I would place my hand on this notice which was issued by the advocate to the proceedings of civil court. Mark ಆಗಿದೆ. ನಾನು ದಾವೆ ಹಾಕಬೇಕಾಗುತ್ತೆ ಅಂತಾನೆ ಅದರಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ, ಏನು ಮಾಡ್ತಿದ್ರೆ. The earliest given point of time, the year of my joining to the service itself, I have.
No. This is not to your employer. This is not to your head of the department. This is again to the education department in the matter of correction of the date of birth in the SSLC certificate. Where is your application to the head of the department?
Can you have a glance at this Annexure D ನಲ್ಲಿ ಇದು ಕೋರ್ಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಎಲ್ಲರನ್ನೂ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ
ಇಲ್ಲ.
And the application which I have made, Lord, 9/6/2021 Annexure F 9/6/33/2021.
Sir, you not made your head of the department as the party defendant. These are all principals, headmasters, ಬ್ಲಾಕ್ ಎಜುಕೇಶನ್
ನೋಡಿ Annexure F ಅಲ್ಲಿ ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ
Annexure D ನೇ ನೋಡ್ತಾ ಇದೀನಿ ಸರ್.
Annexure E ನಲ್ಲಿ
Annexure D.
ಇವ್ರನ್ನೆಲ್ಲ ಪಾರ್ಟಿ
Who are the dependents? Where is your head of the department?
Head of the department ಇದರಲ್ಲಿ ಪಾರ್ಟಿ
ಇಲ್ಲ.
I do admit.
ಇದ್ರಲ್ಲೂ ಇಲ್ಲ.
ಇದ್ದಿದ್ದನ್ನ ನಾನು ಹೇಳಕ್ ಬರೋದಿಲ್ಲ.
Therefore, in terms of Rule 5 of the Determination of Age Act, you are required to give application within a period of 3 years from the date of your appointment, seeking correction in the date of birth to your advantage. That you have not done. That not having been done.
To seek a declaration that the age has to be determined. ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಲ್ಲ.
ಅಲ್ಲ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿ. ಇಲ್ಲೆಲ್ಲ ಚೇಂಜ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಕೊಡ್ಲಿಕ್ಕೆ ಅಂತ ಕೊಟ್ಟಿರೋದು. And my application which is given to the department, if you lordship have a glance at 33/2021. ಅದರಲ್ಲಿ
that is beyond the period of 3 years.
Beyond the period of 3 years ಆಗತ್ತೆ.
Do you have that act with you?
Karnataka State Servants Determination of Age Act.
Section 5.
Or within 1 year from the date of commencement of this act, whichever is later.
Yes. This not having been done.
This I am given to understand, my lord. He has made an application that paper ಸಿಗ್ತಾ ಇಲ್ಲ. ಅದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಸಿಕ್ಕಿದೆ ಬಟ್ ಪೇಪರ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಪೋಸ್ಟಲ್ ಕಳಿಸಿರೋದನ್ನ ಇದೆ, ಆ ಪೋಸ್ಟಲ್ ರೆಸಿಟ್ಸ್ ಇದೆ. It's not that, my lord, I am just briefing my lords in this way.
No.
ಅಲ್ಲ acknowledgement ಸಿಕ್ತು, ಅದ್ರ ಪೇಪರ್ ಸಿಗ್ಲಿಲ್ಲ. ಅದೇ
you should have stated so in your memorandum of petition. ನೀವು ಹಿಂಗೆ ಹೇಳಿದ್ರೆ ಪ್ರಯೋಜನ ಇಲ್ಲ.
I shall amend it and say so, my lord, because 1 year of
No, sir.
will go in vain, my lord. ಯಾಕಂದ್ರೆ 30ನೇ ತಾರೀಕು ಆದ್ಮೇಲೆ he will this writ also become
Just yesterday I have discussed one more petition like that.
ಅಲ್ಲ ಹಾಗಲ್ಲ, ಏನಾಗತ್ತೆ, my lord, 4 years of service only he has rendered in the 17ರಿಂದ 21.
ಸರಿ ಸರ್, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. See, we can't issue directions contrary to the provisions of the statute.
That's what I am requesting, my lords. ಇದನ್ನ ಒಂದು I will redo that and I will make a
ಯಾವುದು
ನನ್ನ petition ಅಲ್ಲಿ ಒಂದು ಇದನ್ನ amendment petition ಹಾಕ್ಬಿಡ್ತೀನಿ ನಾನು. As the lordships have educated me, in fact I am thankful and grateful, my lords.
issue notice to the respondent. Plus learned area. ಆಗಿದೆಲ್ಲ ನೋಟಿಸ್ ಆಗಿದೆಲ್ಲ ಸರಿ ಆಯ್ತು. 2 weeks are granted to the respondents to file statement of objections. List this matter after summer vacation.
ಲೀವ್ ಮಾಡಬೇಡಿ ಅಂತ ಅಲ್ಲ, ಇದಿದ್ರೆ 30ನೇ ತಾರೀಕು ಮೇಲೆ I don't have any say.
Sir, if such orders have to be passed,
limited period but our objection ಹಾಕಿದ್ಮೇಲೆ ನಾನು ಇಲ್ಲ ಅಂತ ತಾವು ವಜಾ ಮಾಡಬಹುದು.
No.
At least to that extent my lords may oblige me.
ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ, by then I find my amended.
No sir.
Your lordship may be pleased. ಯಾಕಂದ್ರೆ 4 ವರ್ಷ
Sir,
ಸರ್ವಿಸ್.
it will be contrary to the provision. Please understand.
I'm not for a moment. ಅಷ್ಟರೊಳಗೆ I trace out that application which I have made to the authorities. I will trace out.
ಸರ್, ನೀವು ಅದನ್ನ ಟ್ರೇಸ್ ಔಟ್ ಮಾಡಿ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ, ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡೋದು ಯಾವಾಗ?
1 ವಾರ ಟೈಮ್ ಅಲ್ಲಿ ನಾನು ಎಲ್ಲಾನು ಮಾಡ್ತೀನಿ.
ಮಾಡಿ. ನೀವು ಮಾಡಿದ್ಮೇಲೆ ಆಪರ್ಚುನಿಟಿ ಶುಡ್ ಬಿ ಗಿವನ್ ಟು ದೆಮ್ ಟು ಹ್ಯಾವ್ ದೇರ್ ಸೇ ಇನ್ ದ ಮ್ಯಾಟರ್. Interim orders cannot be issued like this, sir. Only if the facts are clear and the court is convinced that you have a prima facie case, only then interim orders can be issued. ಈ ತರ ಎಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಕೇಸ್ ಇದೆ only thing, Lord, one small request. Lord, ಇಲ್ಲಿ vacation bench ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಕೊಂಡು ಸಹ same thing is going to happen. It will not change its course. Best your lordship may say ಒಂದು 6 weeks ಗೆ ಅದನ್ನ postpone ಮಾಡಿ. Otherwise, my lord, it becomes infectious.
No, if you want the matter to be taken up before the vacation bench, I will direct.
Vacation bench ನಾನು ಮೂವ್ ಮಾಡ್ತೀನಿ, ಆದ್ರೆ ತಾವು KCB of my lord.
Adi, in 2 days, if you want to file an application for amendment, you file it.
Please.
Adi.
Reserving liberty to move vacation.
In case, next para, in case the petitioner is able to lay his hands on the application said to have been made by the petitioner to the head of the department seeking correction of the date of birth in terms of subsection 2 of section 5 of the Karnataka government servants.
Determination of age.
Determination of age. Karnataka state servants. Determination of age Act 1974. Then appropriate application for amendment bringing those facts on record may be filed. Full stop. In such circumstances, the petitioner is also granted liberty to move the vacation bench
for consideration of interim.
For interim orders.
Please, please. Sorry, my lord.
I have directed you to consider that application and pass orders.
Yes,
so I have not disposed of the matter.
Yes,
it will be coming up on the 28th.
Yes,
but before 27th, you'll have to pass orders.
Because already his representation is being considered. Already objections are being raised. Because
correct. Whatever it is,
yes,
you should have passed an order.
Yes,
so I have directed you to pass orders. You pass orders and place it before.
Much of it. Sorry, Lord. ಏನಾದ್ರು ಪೂಜೆ ಗೀಜೆ ಎಲ್ಲ ಮಾಡಿಸ್ತಾ ಇದೆಯಾ? ಅದು ಪಾಲ್ಟಿ ಯಾರು ಇವರು ಶ್ರೀಶಾಂತ್ ಸರ್
ಅಪ್ಡೇಟ್ ಆಗಲ್ಲ.
ವೀಕ್ಷಣೆ ಮಾಡಿದ್ರೆ
ಆಗಿರಲ್ಲ.